Oh, well, welcome everybody. Good morning. I know I miss you guys too. Oh my God, that's such a good idea. I'm in. Let's do it. Let's do it. I'm totally in. I actually downloaded it to my vape keeps falling out of my pocket. I actually downloaded it to my phone finally. Freak almost fell over. It's like, oh my God, you finally downloaded it to your phone. I did. It's amazing. Guess we're not missing much, huh? Because I have it up. But I expect that Hank will drop the hammer. There he is. There's my buddy. As always, thank you guys for joining us. Welcome to Twisted Tragedies, where we follow all the twists and turns wherever they lead. I am Elise, your host, and we are covering Karen's hearing today that I am expecting to hear about the federal investigation as long as Alessi doesn't talk into La La Land. Then yeah, then we should hear about it. If you would be so kind and you want to show some love to the show, you can do so on PayPal, Venmo, or Cash App. That is where we get our donations. We are not monetized right now. We have to reapply for monetization because of the cult. So that's the only way I can get donations. And my channel runs strictly on donations from my amazing viewers like you guys. So that is how you do it if you would want to. There's a ticker that goes on the bottom. I'll put the ticker up, get that one off the screen. Good morning. Yes, of course. Of course I can, Kathy. I totally space cadeted out and forgot to send links this morning. My bad, guys. My bad. My bad. Give me a second. I did. I space cadeted it out. It's like one of the first things I was like, I'm going to send it. And then space cadet. Space cadet. I'm sorry. I'm like still having my coffee and it's not iced. I'm not happy about it. All right. I'm an iced coffee girl. I'm a Mary Lou's girl. Now, where it is Mary Lou's coffee, it's just not iced coffee. I make it at home, obviously. Here we go. Here we go. Why is BTIM's not popping up here? What's happening? Oh, here it is. Okay. Angie's isn't popping up either. You know what? Kathy, you can just send it to her if she pops on. She might still be asleep. I know you guys are like different time zones here. I forget sometimes that people are like, oh, thank you, Kathy. 6 hours ahead or 6 hours behind or 3 hours ahead or 3 hours behind. I always forget. Hi, Fanny. I'm so sick and tired of this fan. Like, come on, man. I have it on mute right now, obviously, for obvious reasons, as we're staring at the friggin' fan. But I do expect that Hank always takes half the amount of time to drop the hammer and explain the scenario. Other people are like, maybe we'll start by still talking about what happened with the attorneys. I'm not sure that's how they'll start this. I'm really not. Hi, Katie. I don't know if they'll just move on to another motion and then she'll address it later, or she'll address it right in the forefront. Seemed like she was pretty much, yes, please do hit the like button and the share button. I appreciate you guys. Yeah, I mean, I don't think she'll drop the hammer in the first 10 seconds. I think she may have a couple more questions she wants to ask. She may have something she wants to say. Good morning, Anna. Oh, hey, Trisha. As good as it can be, I guess. As good as it can be. Oh, you know what? Hold on. That's going to be really annoying. Let me shut off the TV. I don't know. See, she might want to like think on it some more after asking some more questions. So it's plausible that she may not have a decision today for us about it. She may just ask whatever other questions, see if she can get them on the record saying something fucking stupid like they did. Also, I really want to point out what my shirt says. I wore it specifically for this hearing, okay? And what it says is, I'm going to let karma fix it, because if I fix it, I'm going to jail. That's what it says. That's what my shirt says. And I wore it just for this very hearing today. Yep, sure did. Yep. I also have one that says, I'm a special kind of twisted. That one's a special shirt for me. But it says I'm a special kind of twisted. Also, yeah, wake up, hair, don't care. Sorry, not sorry. Wait a second. Something's happening. I can hear. Hold on. Let's unmute this for a second.
This court is now open. You may be seated. 22-117, the Honorable versus Karen Reed. Can I identify myself for the record?
Good morning, Your Honor. Laura McLaughlin, sit on Good morning, Mr. McLaughlin.
I'm Lord.
Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alex Jackson from the street.
Good morning, Mr.
Volume's
Jackson.
all the way up.
Good morning, Your Honor. Elizabeth Little.
It's ridiculous.
Also on behalf of Ms. Reed. Good morning, Mr. Little.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Leslie.
And good morning, Your Honor.
Boy.
Karen Reed for Karen Reed.
Good morning, Mr. Nettie. Good morning, Mr. All right, so we've got a few things to cover today.
I'm gonna mute myself because you can't hear anything.
We had a couple of questions to finish off about the defense position on the opposition to excluding the ACCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, or Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under dogger grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the.
I muted myself. Well, I unmuted to say that, but.
Police station video. So that's the order that makes sense to me to finish up what we already had scheduled last week, before we do anything else. So the questions that I have. Before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts, you act for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You know that. Do you understand that, Mr. Yannetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Alessi?
Yes, Your Honor.
So each attorney is legally accountable for the actions and statements of the entire team. So now the questions that I have, Mr. Alessi, that you said are welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you call it. Could you stand, please, because I can't hear you.
Yes, I was going to go to the
So
podium.
go ahead to the podium.
Thank you. I didn't want to stand when you were talking.
You could stand. All right, so the pause email is you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. You will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. And then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARCA and Mr. Jackson regarding compensation and retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring, or do you know that to be fact, that there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact, or is that what you are inferring, as you said?
I am inferring, Your Honor, I do not know that as a fact.
Okay. So now my next question is regarding the invoice and the payment,
Ouch.
the fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time
Same time as what, Your Honor?
as the invoice?
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. It seems pretty clear. This was filed, I believe, on the weekend, February 16th. In the Commonwealth's defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with her discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor. I just want to make sure you were finished with your
Go ahead.
question. I learned that invoice was paid Sunday night before February 18th. I'm going to repeat that. I learned,
You don't have
I'm
to
sorry.
repeat it. And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to, so I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions that I did. So that's part one. Part two of the
Part
answer
50.
is, Your Honor, you've referenced that I didn't get to the payment until the middle
Please
of
don't
my
repeat it.
presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through.
Excuse?
And when I got to the
Just not buying
invoice,
that.
before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes.
It wasn't right
was
away.
paid, and I said, and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
That's not what she asked.
The motion, defendant's opposition to the Commonwealth's motion
Not what she
to
asked.
exclude employees of ARCA is signed by you.
Your Honor, it is signed by me, but if I could with regard to 3.3A1. 3.3A1 is not a strict liability.
She's not asking that.
That's the reason why it has knowing in it, is in order to violate.
Did you get the link, Kathy?
3.3A1, the attorney in question has to know with regard to the fact and issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under everything else, particularly Rule 14, it can be no excuse for any attorney.
Okay, just want to make sure.
Me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody. But Your Honor,
That's right.
it's clear in the
No, but.
it's clear in the
No,
case
but.
law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis.
False.
That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing.
Thankfully, you have
Ah,
DoorDash.
I'm
And
sorry.
top-rated shoppers will deliver
Sorry.
groceries right to
I'm
your
a
door as if you
thing.
pick them all yourself.
I can't pay for
For
per
a
month. for that.
misstatement of fact of another attorney unless they have knowledge of the misstatement.
They had
and
knowledge.
knowingly participate.
Stop it.
So I respectfully have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A from everything else in the world, which I agree completely with.
So bad for them. So bad. Yeah, she's about to drop the.
All right, I'm not going to ask other counsel. All right, so let's move on to the next motion.
Your Honor, if I could, the tabs that I had, I've marked them as exhibits. I didn't do that last time. The white book, and I had marked Mr. Brennan has.
She basically just said she's not asking them any more questions because they're just gonna lie, basically.
They're all marked. There are two, Your Honors.
She's done.
February 6th was
She's done.
exhibit 1. So I picked off on 2 and worked it out before. What would you like me to do with each, Your Honor?
You can hand them to the court officer, we'll hand them to.
Well, there you are. Thank you. Thank you, Your Honor. Have you concluded what you?
Yes, but let's look at this one.
Okay.
Ouch. You just got a spanking, bro, by the judge.
So let's go on to your, did the Commonwealth want to add anything?
Oh, she already made her
No,
decision.
thank you.
I think she made it before he ever opened his mouth the first time.
So let's go on, I don't have the Jim, 499. So the motion of the defendant to exclude the testimony of the Commonwealth's witness, James Crosby. And I read it 2 weeks ago when it came in, Mr. Leslie.
Doesn't need to read it again.
Thank you, Your Honor. I'm just getting myself reoriented
Take your
back to it. Thank you.
He clearly doesn't. He's just going to keep lying. And she was done with it at that point. She had other questions, but she knew they were just going to keep splitting hairs and lying. So she was like, yeah, I'm done. Not asking any more questions. Like, this is it. Because what's the point if they're just going to lie? What's the point? There is none. Pointless.
May it please the court. The
Exactly. Toto.
entire proposed testimony of Dr. Crosby
Crosby.
should be excluded because he is plainly not qualified to render the opinions that he is trying to render. And his
Hilarious.
methodology not only is not reliable, but it's not even documented.
Bingo. Because they don't want to work for free. That's why. And they are working for free, supposedly.
Your Honor well knows the inquiry under Dalbert Lanigan, so I won't go through Rentala and the rest. Your Honor's heard it many times before. Under the qualifications prong, the crucial inquiry, Your Honor set the standard for the subject matter of his testimony. And what is the subject matter of his testimony? The subject matter of his proposed testimony is the medical cause of the injuries and wounds to the right arm of the decedent. I'm going to get into how Dr. Crosby tries to camouflage to avoid the impact of the standard Your Honor established. But that is clearly what he is trying to do. And I cite to NDAO 1377, NDAO 1382, because that is where he renders his opinions. For example, he says, this is a preliminary response to your request for my professional expert opinion regarding injuries and defects to the right arm of decedent John O'Keefe. Similar statements. So it's very clear that's the subject matter of his testimony. Your Honor stated with regard to Dr. Rentschler that it is clear to me that in Massachusetts, biomechanical engineers are not qualified to testify as to medical causation of an injury. Key point. Only an MD can do that. That's what Your Honor said was the clear law in Massachusetts. Admittedly, indisputably, Dr. Crosby is not a medical doctor. As a matter of fact, Dr. Crosby is not
Neither
a
is ARCA.
veterinarian. He's not a forensic odontologist. And those are all disciplines that can even get near the type of subject matter that he's looking to opine about. He tries to dodge that very impactful standard that Your Honor established.
There's no chance
By
the judge
saying-
doesn't let this person in, just saying.
Well, you
None,
know,
zero. She let Russell in,
this case
everyone else
is
comes
not
in.
about the treatment of the decedent. It's not a case about the treatment of the wounds on the right arm. And yeah, you have to be a medical doctor to treat, but that's not what the issue is. So I'm okay. It is a total straw man argument. He's creating this treatment. Nobody ever said the way that the issue is treatment. Dr. Russell never said treatment. Dr. Crosby made it up. So he creates this straw man to try to avoid the medical causation opinion that he is given. And I think that's a clear indication that he is very, very sensitive to the issue that he's not a medical doctor. With
Yes,
regard
it is.
to
Talk forever.
his
We all
area of expertise, it can't be more obvious
piece of
than his
hair.
own proclamations.
driving me nuts.
He says the name of his consulting group is Canine Aggression. His purported title is Certified Behavior Consultant. So he himself dubs himself with regard to canine behavior. And that is
Dr.
what
Russell did with
he
bite marks.
is expert in.
She's
And
an
of course,
expert
there's no issue
just from looking at them.
whatsoever in this case about canine behavior. And more importantly, his
Yes,
own
there is.
report doesn't discuss canine behavior at all. So in conclusion, on the qualification,
His
clause,
argument
Your
is-
Honor, Your Honor's standard, he's not a medical doctor. He's therefore not qualified to opine on the cause of the wounds to the decedent's right arm. The court need go no further than the qualifications prong to exclude all of
Be right
his
back.
testimony, because all of his report is regarding the cause of the wounds to the decedent's right arm. And it almost is common sense that when someone is trying to opine on the cause, the medical cause of injury, that if you're not a doctor, with regard to the issue, that you're not qualified. So now let's go to the methodology of Dr. Crosby. His methodology is essentially, he took measurements of one dog, a dog named Chloe, that it purports to be Chloe. He didn't document that it was. There's no documentation of that. But let's assume hypothetically it is this dog Chloe. So what does he do? He takes measurements. This is what he did first, and I'm going to get to what he's just recently submitted. So what does he do? He takes measurements, anesthetizes the dog, takes measurements of the teeth, And then he takes those measurements and he tries to apply them to photographs of the decedent's right arm. And he basically says in his methodology, I am measuring the distance between the canines, I'm taking other measurements of the dog's dentition, and then I'm going to compare them to the decedent's right arm in a photograph, and I am going to opine that the measurements of the dentition don't match up with the measurements and distance of the wounds on the right arm. Therefore, this dog couldn't have caused these injuries, and therefore these wounds are not caused by a dog. And this dog, so he says not only not Chloe, but no dog. Then he goes even further and he says, and I believe the cause is some sharp object. So now we have him going even beyond a dog, and he's claiming that it was caused by a sharp object. It just goes to show you how far he is afield of what he is doing. So he's not a medical doctor, so he's now performing essentially another diagnosis of the wounds to a human. He provides zero evidence of any experience in determining whether a wound on a human is caused by a dog or a sharp object. And his methodology, Your Honor, is remarkable for several other reasons. First, he uses a hospital wristband to take his measurements because the photographs of the autopsy didn't have the ADFO ruler in them. So he tries to use the wristband as a surrogate for his measurements. He provides no support whatsoever for using that surrogate. And what do I mean by support, Your Honor? For an expert to justify a methodology, they've got two ways to do it. The most prominent and common is that the methodology is generally accepted in the relevant scientific or medical field. He provides zero, and I mean zero, words to tether his methodology to a commonly accepted practice, meaning his methodology that he used, he doesn't show any support for that at all, let alone it's commonly accepted. He doesn't cite to one study, he doesn't cite to one scientific publication that says
2 plus 1 is equal to 3.
Super!
Did you see that? Keep it up.
Did you see that? The egg is starting to crack. We are so close to finding out what's inside. Oh my God. Now it's your turn. Click here and solve these problems yourself.
Caring for my daughter at home has become so easy since I discovered Entire Care. I'm compensated $1,500 per month for the care I provide anyway. And finally, I have enough money supporting us while being the best possible caregiver. And I have the option to contact a care professional for support at any time. Having all the resources I need and having an actual face to talk to makes a huge difference. Entire Care provides everything I need: personalized coaching, important resources, emotional support, and payment. If you take care of a loved one at home, you just have to give it a try. Get the support you deserve and visit entirecare.com.
They say the methodology employed was based on facts, science, and study. What do they cite to? They cite back to Exhibit 1, which is his report, which has not one footnote, not one reference in his report to support it. So the statement the methodology employed was based on fact, science, and study is a bald conclusion with no support at all. and this was the opportunity for the Commonwealth. I put it pretty clearly what the challenge was for them to come back and say, oh, no, the methodology, it's recognized, and here is the basis for it. It gets worse for the Commonwealth, Your Honor, on the methodology, because there are potentially some methodologies that might be used. They're called into serious question, but one of them for humans, not for dogs, is what the ABHO talks about is the dental mode and overlay method. And that is basically take a mold of dentition, and in the most recent submission, the Commonwealth put in, very belatedly, but I can deal with it, that Dr. Crosby now says he took molds of the dog's teeth. And so I'm going to accept arguendo that he did that and he did it correctly. But what he misses is those molds are meaningless unless you come to part 2. You've got to take those molds and compare it to something. And the something is what's called the overlay method. And what is the overlay method? And this is all set forth in our opposition. And I've got citations to the exhibits, which I'm going to go to. The overlay method is the part 2 you apply the mold to. So what you do is you take tissue samples of the wound and you make, there's a variety of techniques you can do, but you basically create the wound on a model, and then you compare the mold to the model to see if they match up or don't match up. He never engaged in the second part of what is, even with 2 parts, is a questionable methodology. He doesn't employ the overlay method, the part 2. So the molds that he took are meaningless unless you have the overlay to go with it, because that's what you compare them to. More importantly, the ABHO makes it clear that the only people that can do that are forensic odontologists. And even then, the science is very questionable. What he also does in terms of, and also for his methodology, where it's just a measurement, he provides 0 citations, and the Commonwealth provides 0 support for taking measurements in molds and comparing them to the wound. 0. So what are the other errors of Dr. Crosby? And these are not mere differences of opinion, Your Honor. These go right to the methodology. And we put in an affidavit of Dr. Russell, who is the medical support for his errors. So Dr. Russell goes through and talks about all the errors that Dr. Crosby caused in his analysis. The first, she says, is that he treated the arm of the decedent as if it is a static, plastic mannequin-like object. And what is meant by that? Your Honor may recall Dr. Russell stated that when anyone is attacked by a dog, they move their arm, they flex their arm, and they move it, etc. And that can cause a dog's teeth to have an incomplete bite, etc. Dr. Crosby doesn't account at all for that movement. So what he did was he treated the arm as if it never moved, and then he said, I'm going to take the dog's teeth, measure it, and then I'm going to take those measurements to a static arm. And he says it's just the distance is too far off to say that it was from any dog. Well, what he didn't account for is that when the arm flexes up, as it always happens in the defensive wound mode, those angles and those distances change. They get closer together. It's common sense, but it's also medically supported by Dr. Russell. And she said when you do that flex, that is going to make those wounds approximate the canine. But the fact is, her main point is he never accounted for that in his methodology. It's not an opinion. It's a methodology. So, and again, if he were to cite to a study that would say, no, it's okay to just treat it illogically as a static object, he might have some support, but he doesn't, and there is nothing in the literature because nobody believes that's at all realistic in a dog attack. So that's her first criticism of him. She also states that the photos that he used, there's no documentation of who took them, how they took them, and we all know in forensic photography, those people who take those photographs have to be trained, they have to give a fair and accurate depiction, and you can look at one of the key photos, it's blurred. So it's obvious that there's a problem with one of the photos. She also aptly points out that there's not one citation in his report to any support for anything that he did. The Commonwealth, in their opposition, spent more words going back trying to attack Dr. Russell than they did trying to support their own expert's opinion. And I just counted the lines. I'm not going to tell you what the count is, but there's more lines basically trying to say that Dr. Russell's entire testimony and opinions lacked adequate authority. My, she had, I think, 31 footnotes in her report. The one who entire opinions lacked adequate authority is Dr. Crosby. The other criticism that she has on the methodology of Dr. Crosby is that he didn't account for the dimpling and pinching and piercing of skin, human skin, when there's any pressure, particularly with a bite. It moves, it tingles, it hits the muscles, etc., etc. He gave no account for the condition of human arm and skin and anatomy, perhaps because he's not a medical doctor and doesn't know the area. So with regard to the Commonwealth's response, I'm appreciative of the fact that
With regard to your talking, shut the fuck up.
So what they say is in the second paragraph, they said his master thesis, the specific use of evidence in the investigation of fatal dog attacks, has been peer reviewed. So what did I do? I went and read both of his theses. What I found is particularly probative of the issues I just raised. So I looked at his and read his, I read 179 pages of his 2016 Master of Science thesis that they cited.
So you read 200 out of thousands of pages. Wow, you really did your homework.
He talks about, on page 46, defining bite mark evidence. A bite mark can be generally defined as a pattern made by teeth in a substrate. A dog bite injury is a pattern industry. Your Honor may recall the absolute probing of Dr. Russell on patterns and the arguments that patterns are a soft science and you can't rely upon them. And lo and behold, Dr. Crosby's first sentence in his master's thesis is a bite mark can generally be defined as a pattern. A dog bite injury is a pattern injury. So I appreciate
Context matters,
thesis
dumbass.
that he confirms Dr. Russell's methodology.
He's an idiot.
What he doesn't do in his thesis
He's a
is he
dumbass.
mention his own methodology that he used here. In
He did, though.
179 pages,
You moron.
there is now one reference to the methodology he used.
Context
in
and
his
details
report.
matter, Alessi. Context and details matter.
With regard to, I mentioned the ABFO.
That's why
the
you should
American
never just
Board of
read one
Forensic
sentence or something.
Odontology, and I mentioned how difficult that is to do that correctly. In his thesis, he states, and I quote on page 61, the guidelines, however, do not indicate the criteria necessary for using each method to determine whether the bite mark can be related to a person's dentition and with what degree of probability. There is no science on the reproducibility of
Bite
the
mark.
different methods of analysis that lead to conclusions about the probability of a match. a very, and I couldn't agree with Dr. Crosby more on that.
Once again,
He
context
then talks about
and details
in
matter.
his thesis
Moron.
about the fact that there's no accepted methodology for dog bites, even forensic examination of dogs. And what is that standard? That's the mold in the overlay, right? He never did the overlay, and he was proposing in his thesis that that might be a way to go, but he recognizes that it is not reliable. And then on page 66, the last paragraph I'll cite in this, he says, reliability in human cases is under examination. Hard statistical agreement on consistency is not present, so each evaluator will have to make the best argument in each case. As case law develops and examination science progresses, we can hope that standards will be established and accepted. Until then, a forensic bite evaluator can best develop their opinion based on whether the bite mark in question is consistent or inconsistent with a pool of potential subjects established by other means. Here we go. This opinion should be heavily influenced by supportive hard evidence, such as DNA, physical observation, blood, tissue recovered from the gastrointestinal tract, and other factors. So the ABO, he agrees with the fact that you just, even with this methodology, you've got to have it supported by this hard evidence that he doesn't have anywhere near in his methodology. And what he also talks about is relying upon a medical examiner for this hard evidence. And what we point out in our opposition,
You just argued against
he never worked with
Dr.
a
Russell.
medical examiner.
You
for his
fucking
methodology.
idiot.
He never worked with a forensic odontologist.
She has
In
no
the case law that
evidence
we
to
point
back up
out,
this stuff.
even in this
What a
very
moron.
suspect area of bite mark analysis,
Good job arguing
even
against
in
your
the
own expert,
cases that
dumbass.
allow it for humans, they are all cases where there had to be a forensic odontologist or a medical examiner involved for quite obvious reasons. So his master's thesis supports the methodology of Dr. Russell and provides not one mention of his methodology. So then I said, well, maybe in his PhD thesis, which is more recent, 2023, maybe in that thesis that the Commonwealth did not cite. So I went and read 143 pages of that, and there is zero mention of his methodology, and that was just 2 years ago. So what does he say? In his whole thesis is entitled Dog Bite Related Human Fatalities in Scientific Study. So it's really about fatalities, and here it's undisputed that the decedent, his death wasn't caused by a dog. It's a dog attack, but that was not the cause of death. And his whole thesis is about the problem statement. He defines his thesis on page 18. One of the problems is the lack of standardization of methods and reporting. Lack of standardization manifests in several ways. So basically what he did in his thesis is he went through and talked all about when there's fatalities, there's ways, and he creates a classification system on page 63. But his classification is on behavior.
You're literally
Sentence,
arguing
page
against your
63.
own expert too, you
Classifying
idiot.
dog bites. This provided the opportunity to develop a protocol for classifying the incident from the dog's likely perspective based on its behavior. That's his thesis. It's got nothing to do with, is this wound caused by a dog bite? And so on the point
No, she should have, Kathy. She
needing
should
a
have.
medical examiner, needing someone like a forensic pathologist to be involved, he agrees. Page 125 of his PhD thesis, first full paragraph. Where possible, medical examiners or other examining experts should document the location, extent of wounds, and try to determine which wounds may have been antemortem, perimortem, postmortem. This may require histological analysis by a forensic pathologist. So he mentions what medical examiners should do, what a forensic pathologist should do. He doesn't even begin to suggest that he should do it or that he is even qualified to do it. So in sum, Your Honor, with regard to Dr. Crosby, whose degree is in veterinary science, I don't know what that is. Dr. Russell doesn't know what that is. It's certainly not a veterinarian, although if one reads it quickly, one might
You
think
don't know what veterinary science is, you idiot?
He's not. He was a police officer for 22 years. And even then, he wasn't like a canine police officer. He had an interest in them then. And it wasn't until he retired that he became active in dog behavior and how dogs behave, if they're aggressive, et cetera, et cetera. So why is it, Your Honor, that we respectfully submit that he cannot testify with regard to the subject matter of his report, which is the medical cause of the wounds on the decedent's right arm? He's not a medical doctor. He's not a forensic odontologist. He's not a veterinarian. He has none of the qualifications to do that. And he surely doesn't have any qualifications to say it wasn't a dog, but it's a sharp object. And then with regard to his methodology, he doesn't document at all how that methodology is generally accepted. He doesn't even, nor does the Commonwealth even talk about the non-exclusive Daubert factors and how they might satisfy that alternative. And lastly, when he speaks and writes a master's thesis and a PhD thesis of just 2 years ago, he doesn't even mention the methodology that he used. So, Your Honor, in Your Honor's opinion about Dr. Russell, stated that it was a close call for Dr. Russell in her ability to testify. If it was a close, no, not if, since it was a close call for Your Honor, I believe it is as distant a call as possibly could be made with Dr. Crosby. So I respectfully request that he be excluded. There's no need for a Daubert hearing. It's plain on the papers, and it's not something that is curable. The Commonwealth tried to submit very recently a mold. Interestingly, they never tried to document the methodology, tether it to study, show that it was recognized. They've now had 2 tries at it, and they haven't come close, and I'd urge the court to reject it. A jury should not have to hear from a dog behavioralist on what was the cause of the wounds to the right arm of the deceased.
All right, thank you very much. Mr. Brennan, before you begin, Dr. Crosby is not going to testify that this injury appeared to have been caused by some sharp object, is he? Can you plan on bringing that in?
I wouldn't ask him to do that, no.
All right, so I'm hearing a motion.
Yeah.
Sure, yes.
Mr. Releasy tries to point out differences between Dr. Russell and Dr. Crosby, and there's always going to be differences between experts.
That's the whole
One
point.
difference is that Dr. Crosby has actually testified in state and
Hey,
federal courts regarding
you're
dog bites
awake.
before, where Dr. Russell never had before this case. And so
Hey, all.
in preparation for Dr. Russell, we provided not only a CV, a history of his education, but also an actual report. An actual report of what Dr. Crosby did, the methodology explaining his analysis, his examination of Chloe, and his testing. And that was provided to the defense prior to any testimony that he will have on the stand. When we look at the summary that's provided, Dr. Crosby has testified in numerous cases before. So those courts seem to disagree with Mr. Releasy's opinion. In addition, Dr. Crosby set out in his package numerous different journals and publications that he relied upon in this case. There are a number of publications, I won't read them all to the court, but we can see that he relied on books regarding bite mark evidence, human bites versus dog bites, forensic study of dog attacks on humans, a focus on bite mark analysis. The list is comprehensive. Variable mechanisms of dog-related deaths, life-threatening dog attacks, a devastating combination of penetrating and blunt injuries, fatal and near-fatal animal bite injuries, on and on. These are materials that he has studied, he's familiar with. Dr. Crosby has the qualifications to testify, not simply because he's testified in state and federal courts before this case, but also because of his studies and his education. It seems as though Attorney Lisi is trying to bind the court regarding a comment of the necessity for a medical doctor. There is no requisite that an expert in this field needs to be a medical doctor.
Bingo.
There is no cases that they provide that bind that limitation. The qualifications of Dr. Crosby are outstanding and significant. He studied at the College of Veterinary Medicine. He completed coursework in forensic animal behavior analysis, animal crime scene, bite mark analysis, veterinary forensic pathology, forensic crime scenes. He is often called to go to autopsies around the country to study wounds and determine if they are bite marks, if they are dog wounds, and if they can be attributed to a particular dog. He served as acting chief.
Is that in the papers?
The different autopsies he has, and I can supplement the autopsies he's been to, and I can also supplement specific cases where he's qualified. He has listed a number of cases in the back of his package.
So do I have the exhibits that I have are attached to the Commonwealth's, the defendant's motion?
They have.
I don't know that I have all the reports.
Exhibit 1 has Dr. Crosby's report that has all this information in it.
Okay.
And as I mentioned on a previous tape, Dr. Crosby actually went and examined Chloe. And when he did that, he verified that it was in fact Chloe. He did molds of Chloe, and there was a subsequent report regarding those molds, which clearly demonstrate that the distance in those wounds are not anywhere near consistent with Chloe's spacing in his teeth.
So sort of as an aside, based on what Mr. Leslie argued, the verification.
So the pipes burst at my apartment.
To the door to the bite mold analysis report of Dr. Crosby, which is not in this package.
I think that's attached here. I have the photographs.
But the wounds
That's part of the original report, but then he actually took a mold
by a sharp object, she said?
Chloe's jaw and teeth, and then I asked him to supplement the report regarding the mold.
And that's been provided to the defense?
It has, but it's not been provided in this package, so I can provide that to the court.
I'll explain that after. By a sharp object,
So I'll
so,
supplement those.
because he's not a doctor, she doesn't want him to testify to what
In
it was
addition
caused
to
by,
his experience, he was chief of animal care protective services of the city of Jacksonville.
which is
He had
normal.
oversight and approval of criminal investigations. He trained staff in dog bite and dangerous dog investigations. He served as the Animal Control Division Manager for Bay County, Florida from February 2008 to 2010. He has training and experience, including certifications in humane euthanasia of animals, legal restrictions of methods and reasons for euthanasia. He's investigated numerous complaints of dog bites, and dog behavior. He's published. I had shown the book to Dr. Russell when she was cross-examined. He has a number of engagements where he teaches. Dr. Crosby is well recognized in the field. He has employment in other projects other than his business. It includes a research associate canine brain project in 2023 to current. It's associated with Harvard University. Duties include the investigation and documentation of dog bite and related human fatalities. Also, division management consultant for animal care and protective services, City of Jacksonville in 2016. He is a professional dog trainer, behavioral consultant. He has provided expert witness testimony in cases of dog bite, dog attack, dog-related fatalities. Now, in Dr. Crosby's report, he outlines his methodology, and you can see it is specific, it is detailed, it is consistent. And so when we compare I'll refrain from getting into too much of a comparison. When we see the actual study
Very.
of dog bites, we see something different in Dr. Crosby's report. They're not unsupported claims that change from time to time.
That's
You can
right.
see that there are the pictures of Mr. O'Keefe's arm, and we can see the band in which she used to measure. You can see multiple pictures of Chloe's jaw, mouth, teeth, canines, incisors, and then you can see that
Incisors.
he has measured the distance of all of those teeth specifically. And then in his methodology, he outlines each group of lesions, specifically lesion group 1, lesion group 2. And then he goes into an analysis of the different groups of lesions. He explains why they are wholly inconsistent with both a dog bite and any animal bite. And he also describes and explains that the distance between the wounds are totally dissimilar to Chloe's mouth. He does look, as Mr. Lisi suggested,
Yep.
at other support, such as DNA. And in fact, he embraces other support. In this case, there is no canine DNA.
There's none. There's nothing.
Significant to Dr. Crosby because in virtually every case, he finds canine DNA. So he does look to alternative sources, and mindful, there was pig DNA found. So it wasn't as if the sample was obliterated or destroyed and there was no materials available for testing. It's just the unfortunate consequence that there
nothing
is no animal DNA. And so while there are different
I
methods,
see Ted.
and some of the things that
Come clean,
attorneys
Ted.
talk about dentition deal with human biting, not dog biting. His methodology is set out very clearly on how he came to these determinations, what he did in his study. He actually engaged in an investigation in this case before providing his opinions. So Dr. Crosby is well qualified. He has been accepted in state and federal courts before this case.
Yep.
He did a thorough examination. He has ample support for his training and experience, and his opinions are soundly based, not on hypothetical or rhetoric,
Science.
but on the facts, on the details in this case. He has never changed his position from one event to another. It has always been the same in this report, has not wavered, and he is highly qualified to appear in this case in rebuttal if necessary, if Dr. Russell is to take the stand and provide some or any of the opinions that she provided before.
All right, so just to be clear, the Commonwealth does not intend, if I permit the testimony, does not intend to call him in your case in chief?
Absolutely not.
Okay. All right.
Case
Mr.
in
Leslie,
chief. Wait, what?
Thank you, Your Honor.
Not intend to call case in chief? What? I'm not understanding what you just said. They look worried. As they should.
The Commonwealth
Look at
did
you, Nettie.
not address in its presentation, you heard
Oh, boy.
one probative, legal, or factual point I made because they can't specifically.
No, because it's garbage.
The Commonwealth just stated that Dr. Crosby has testified in
Oh.
court numerous times.
Thank you, Chief.
On what? It's important, you can be qualified to testify, and if it's what Dr. Crosby does on behavior, dog behavior, was the dog an aggressive dog?
My
I get
brain.
it, but the Commonwealth never said that in even one of those cases, Dr. Crosby testified on whether the cause of a wound was from a wound to a human was from a dog. Wasn't mentioned. There's no case provided. As best as I could, I looked at those cases. I couldn't find many of them, but I didn't see any indication that he testified and was allowed to testify that the cause of this wound on a human
He's
was
not
from a
testifying
dog or
to
a
that.
specific dog. Point number two.
Oh, no. Yeah, he is. To that, not
Mr.
to the
Brennan
sharp object.
mentioned he cited numerous journals. Your Honor, I would ask
Oh,
the
God.
court
Shut
to
up.
take a look at his report.
He
There
did.
is now,
Hold on, so that's exhibit 1. It's going
yes,
down.
exactly.
Just give me a minute. Just put it back.
The judge is totally done with like his nonsense. It's exhausting.
Every page. The point is, there's not one footnote in any of his reports. So he does go through his purported methodology I've never said he didn't present a methodology. My
Yes, you
point
did.
is his methodology is not accepted, let alone generally
Accepted?
And nowhere in his report does he say this methodology,
What?
this measurement methodology, is accepted at all.
Ye-
And you have to.
It's a
either show
rebuttal. Witness.
in Dalbert Lanigan that either your methodology is generally accepted in the relevant medical community, or that you can satisfy the Dalbert factors, which I'm going to get to. But Mr. Brennan said he cites numerous journals. Your Honor, this is what Mr. Brennan has to be referring to. If Your Honor would please turn to the end of the report. This starts on NDAO 1400, very much toward the back.
Okay.
So he's got it in alphabetical order. Importantly, the page before 1399 at the bottom is entitled References and Materials Consulted That May Affect My Opinions in This Case. You can't have an expert report that does a data dump of references and says, there might be something in here that I might have considered that might affect my opinions in the case. And that's exactly what he did. And the only conclusion I draw from this is his methodology isn't in any of them, because if he had to cite which one of these contained his methodology, he would have to be creating fiction. So when Mr. Brennan says he cited numerous journals, well, he did, but where does he tether his methodology to one of them? He doesn't.
It's to all of them. That's why you cite
because his methodology,
you idiot.
to the best of my research and Dr. Russell's, has never been accepted by anyone.
Yes.
So then
Daniel.
what Mr. Brennan stated was that he participated in autopsies. My point exactly. He participated in them. He obviously doesn't perform autopsies, so it had to be with a medical examiner or forensic pathologist. He didn't do that in this case. There's no statement by him that he worked with a medical examiner, etc. So I think the inference the Commonwealth wants Your Honor to take is because he's participated in autopsies, he must have been the one that determined whether or not the the wound is from a dog. There is zero evidence in any document from which even an inference can be taken. There's no foundation fact from which the inference can be taken that that's what he has done. He mentions a book that he tried to use on Dr. Russell and for whatever reason immediately truncated it. I will just reference that book is not peer reviewed, but importantly, nothing in the book that Dr. Crosby wrote, and I thank Mr. Brennan for bringing it up, there's nothing in that book that sets forth the methodology that he used here. It's not there. With regard to he's well recognized in the field, that's exactly what Mr. Brennan's words he just used. He's well recognized in the field. What field? For Dalbert, you gotta have experience in the subject matter. I don't know what he means by field. Is it dogs, dog behavior? In Dalbert, it's the subject matter, the testimony, which is what's the medical cause of the wounds to right arm. That's not documented. That's not even stated. He mentions Harvard, which people use for obvious reasons. You know, it's Harvard. But what is it that he is participating in Harvard in? And this was from the words of Mr. Brennan, canine brain behavior. I didn't hear anything that he's at Harvard opining on the cause of.
Jordan Orme is a podcaster and YouTuber with over 1 million subscribers. He relies on Riverside.
So if I ever need to film.
Said that he outlines his methodology. I agree with Mr. Brennan on that. He does outline the methodology that he uses. But fatal and problematic is he doesn't tether it to a study to say it's generally accepted, which is the key inquiry under either Commonwealth v. Davis, common acceptance, or the Daubert-Lanigan, the 9 exclusive factors. And then the last point that Mr. Brennan made is particularly telling. He said Dr. Crosby bases his opinion on facts. That's not the Daubert inquiry. You've got to base your opinion on a reliable methodology.
So you don't do facts?
Facts, yeah, they are somewhat relevant, but
they're only somewhat relevant.
So I am still, after all this time we've argued this, waiting to see.
Then your own expert is
study.
out. She has no methodology.
Documentation that the methodology that Dr. Crosby used, that a medical doctor, Dr. Russell, so thoroughly
She had none.
criticized, where is that methodology documented in one of these many references at the end? No footnotes in his study. I believe, and why isn't it, Mr. Brennan didn't respond at all to my points about Dr. Crosby's 2 theses, where you would expect his methodology to appear, and it's completely absent from there. So the question is, in conclusion, where is the home for his methodology? Where is the home? Where is the home in the scientific literature? It's an orphan methodology. It has no home because it's not generally accepted. So he is not qualified
By who, you?
under Daubert-Lanigan, and his methodology is an orphan. And for those reasons, not only can he not testify with regard to
Oh, you decide now?
whether the clause is a sharp object, but he has not, the Commonwealth hasn't even begun to meet its burden that
Of
his
course it has.
methodology is reliable for
Yes, it
all
has.
the reasons that I have stated. And a good part of my position is based upon Dr. Crosby's own report that doesn't tether it to a study or general acceptance. And Dr. Crosby's own theses that don't even mention the methodology that he is trying to put forth in this case.
Anything else, Mr. Brennan?
Briefly. On page 6 and 7, Dr. Crosby offers court cases in which he has testified and provided expert opinion. I will give you specific cases where he's been qualified in state and federal court. Mr. Lisi harps on the idea of methodology. If we remember Dr. Russell's testimony,
Had none.
it wasn't until later in her testimony that she introduced this idea of pattern recognition analysis.
Yep.
And we hear very little about the details. What we knew or learned from Dr. Russell is that she couldn't identify any of the wounds, none of them independently, just collectively. In fact, I think she opined that she was the only expert in the country that really could perfect the art of pattern recognition analysis.
Yep, she did.
Attorney Lisi's arguments are the fact that he doesn't like the way Dr. Crosby wrote his report. But what I can say for Dr. Crosby is at least he wrote his own report.
Bingo.
And when you look at Dr. Russell's affidavit in support, there's something, to be intellectually honest about it, striking. Kind of like her original report, where it was clear to me that it wasn't fully written by Dr. Russell. You look at that affidavit, it is not consistent with the testimony or the mannerism or the way that expert speaks. And so a lawyer can craft an affidavit and help craft a report so it meets their idiosyncrasies, but that is not the arbiter if somebody's qualified. Dr. Crosby is qualified, he has experience, he's testified and been accepted by courts before. Thank you.
Okay, so before we move on to the next motion, it was filed after the other motions that we finished here. It was filed on February 21st, I believe. Defense motion to exclude, February 21st. Defense motion to exclude certain testimony of Commonwealth witness Robert Gilman, and in the alternative of Daubert hearing. So the last time we were here, I wasn't sure we would reach this. I think
Yeah.
it had just been filed.
Because they
So
did.
I don't have an opposition from the Commonwealth. I don't know if you wrote one, if you planned on writing one, or if you just wanted to go forward, and also whether you're prepared to go forward today.
We do not have a written opposition, but we are prepared to go forward today.
Okay, so I will hear you, Mr. Leslie, this is you again, right?
Oh, God.
So I'll hear you. And this is paper 515.
May it please the court. Mr. Gilman, a meteorologist, is attempting to opine on the hardness of soil conditions at 34 Fairview on January 29th, early morning 2022. He states in what is a certified weather statement, that's quote, certified weather statement, many things, and we don't challenge his statements about what the temperature was and precipitation. But what we do challenge is his opinion with regard to the hardness of the ground.
Yeah, exactly. Good for you for knowing that.
With regard to
Dummy.
his qualifications,
He's very well qualified.
he is not, his qualification to opine on the hardness of the ground.
Or what? He's a meteorologist.
He is not
Dumbass.
a geologist.
Doesn't
He's
have
not
to
a
be.
pedologist, i.e. a soil scientist. There's a specific field for that. He's not a hydrogeologist, which is a scientific discipline that blends water movement in the subsurface, particularly the soil. He's not a hydrologist, which deals with solely movement of water, whether it's in any kind of media, soil, etc. And he doesn't purport to have any of those qualifications. He doesn't even state that he took courses in college that would have even educated him on soil hardness and the effect of precipitation with regard to the hardness of the ground. But perhaps the most telling statement that he makes is he puts his opinion in quotes.
Bingo, Casey.
So his certified weather statement is hard as a rock, I believe. I'm looking for it.
I'm sorry, there are a couple of exhibits attached to your affidavit,
Uh-oh.
Mr. Leslie.
Yes.
The court officers are talking about
I
something.
don't see any.
I'm sorry, Your Honor. It's Exhibit 1.
Okay.
Is his February
All of a sudden.
3rd, 2025 quote certified weather statement.
Okay.
That is it. And at the bottom of it, it's got in the quotes the
Okay, I see. All right, I don't see anything that says certified weather statement. It's an email, right?
no his report is exhibit. Well, it does state certified, and I'm quoting certified weather statement.
Is it NDA 02802 and 803?
It is exactly that.
Okay.
Yes. So Your Honor, he puts his opinion in quotes, which to me is an indication he's speaking in lay terms. I've never seen an expert put an opinion in quotes. And he does not tether that opinion to any methodology. As a matter of fact, Your Honor, and that's the entire basis for what the Commonwealth is proffering is support that one, he's qualified, and two, that his methodology is reliable, but he doesn't even state what his methodology is that he used to come to that opinion. I've never seen a proffered expert not even state what the methodology is. He doesn't say how he came to that conclusion. So it's the burden, as we know, of the Commonwealth who's offering the witness to demonstrate by a preponderance of the evidence. They don't even have evidence, let alone a preponderance of the evidence. They don't state a methodology, and they put the key opinion, the only opinion, in quotes. And, Your Honor, there is a deep and typical of science, complex way to determine hardness of ground. And he doesn't even begin to discuss that whole science. And Your Honor may recall in previous Delbert Lanigan hearings, I cited to the Goodman case, the Pasteur case, and the courts in Massachusetts has said, in addition to going through making sure you've got a methodology, the court can also use it's the words of the court's common sense. So in addition to all the defects that I just covered, has anybody ever, all of us have heard a meteorologist in many different fora, most prominently on TV, talk. And what do they talk about? They talk about the weather, the forecast of the weather. What is the weather? We all know what it is. I've never heard a meteorologist say, today is going to be 22 degrees below freezing, there's going to be precipitation, and the ground is going to be hard as a rock. I never heard it, because that's...
Need a UGC video for your business? Find me and many other skilled creators on Fiverr. Or you could grab a
of meteorologists. And interestingly, the Commonwealth doesn't cite and document one instance where Mr. Gilman has previously opined on the hardness of the ground. Not one. So in conclusion, Your Honor, he's not qualified in this area. He doesn't even state a methodology to come to the opinion, let alone show that if he had a methodology, it's reliable. He puts the opinion in quotes. I think the only reasonable conclusion from that is he's using a layman, like an idiom, a term that people just use. You know, his head's as hard as a rock, whatever. But that's not science. And in order to give an opinion to the jury, the whole purpose of general acceptance, the whole purpose of Daubert, is it has to be based in science, and it has to be the methodology. There's none stated, and for that reason, and the others I've mentioned, Your Honor, Mr. Gilman, the meteorologist, should never reach a jury to talk about hardness of the ground.
Yeah. Okay.
Thank you. Mr. Brennan, first question, do you intend to call this witness in your case in chief or for rebuttal?
I do, case in chief.
All right, I'll hear you.
Thank you. The Commonwealth proposes calling this gentleman to talk about the weather conditions leading up to the night that John O'Keefe was killed. Talk about the temperatures, the wind conditions, also the snowfall. It seems that the only complaint the defense has is the ultimate opinion that the ground at Fairview was hard as a rock. I think that concern is easily remedied. I do not need to ask this expert if the ground at Fairview was hard as a rock. I can ask him about the documented temperatures, the winds, the snowfall, what makes the definition of a blizzard, how many hours have to elapse in certain conditions to be a blizzard. Also, he can measure the snowfall as it accumulated that night into the early morning hours because there's statistical evidence about it. And I would like him to talk about how ground freezes. Without giving an opinion that this ground was hard as a rock, he should be able to testify that over a period of time, the frost below freezes the ground. I don't need or would not ask Mr. Gilman to talk about the ground hard as a rock. We have a handful of first responders who will give lay opinions with common sense that the ground was hard as a rock. And state police who excavated can testify to that very thing. So Mr. Gilman does not need to offer that opinion. If that's the only thing offending the defense, I think we can resolve the issue.
Okay, what do you say to that, Mr. Lawson?
Yeah, what do you say to that? She's like, what do you say to that, asshole? Yeah, they're off in New England a lot. You're right about that.
Elise, turn your mic volume down a little bit. You're maxing out when you talk loud.
I think the Commonwealth very much recognizes the shortcomings that I mentioned, but its proposal to have a meteorologist talk about how ground freezes is still very much problematic, because just by way of example, how a ground, whether it's frozen or not, and how it freezes, I will give, Your Honor, citations to scientific studies that address and techniques as to how one has to do that. Benjamin J.G. 2005, freeze-thaw effects on penetrometer resistance and shear strength.
Why don't you propose it right now?
Was
that just a Google search? I saw that you had it right here.
Actually, Your Honor, the answer is no, it's not a Google search. I actually consulted with the former head of the National Academy of Science on geology, Dr. Donald Siegel, who told me and gave how it is that one determines whether or not ground is even frozen.
Okay, so that would be helpful to me. Is there any objection to the Commonwealth to me getting that?
Not at all. Happy to provide it, Your Honor.
Do you want to provide a copy to Commonwealth as well?
I'd be pleased to provide a copy to the Commonwealth.
All right, so I'll take this under advisement. So how long do each of you need to get me what you said you would get me? The Commonwealth, the articles, and the qualifications, the cases and the qualifications of Dr. Crosby?
I can have that to you today.
Great, okay. And those articles, Mr. Alessi, that you were just citing, when can I get those?
Do you want all the citations or the articles themselves?
If you've got the articles, if you've got a copy that'll save me from having to find them and read them, that's fine. If you just gave me the links, I can do that myself.
I'll get you the articles, Your Honor, in the text, and it's probably going to take me 2 or 3 days.
Do you have the links? Do you have a list?
I've got a list right with me today.
Okay, so I'll take that. And that'll save you from having to print the articles.
Would you like me to hand it to the court officer?
That would be great. And you'll provide it to the Commonwealth as well. Is that your only copy, Mr. Alessi? Did co-counsel have copies?
Oh, no, the co-counsel doesn't have any of this, Your Honor.
Okay.
I just need to black out something here that's.
Sure. You don't have to do it right now. Do it before you leave.
I'll do it before I leave, Your Honor.
That way there, we'll see to it. Jim, can you get a copy made for everybody? All right, so now, because we're doing them in the order they came in, Commonwealth's motion to impose sanctions. This involves a transcript that I've read. I've listened to the actual recording. Maybe it makes sense to take a 15, 20-minute recess. Now, does that make sense to everyone? Okay.
All right, good morning, please.
Is the Commonwealth going to play portions of this or not? The flash drive has been impounded because I understand the nature of it. Is it all, are you referencing just the transcript? Actually, we're going to see Councilman.
Ooh. Sidebar. She said sidebar. Sidebar.
I think we got a super chat. I think we got a super chat.
I had to. I'm sorry. I had to. I had to. And free Karen Read, everyone. Free Karen Read, everyone. I had a $10 donation from LG, my friend. Thank you. I appreciate you. I had to play your favorite video for you too, because I know that you love that one. Absolutely love that one. So we had to play it for you. And it says, thank you for playing the court stuff. Of course, of course. I appreciate you, dude. I do. Yeah, exactly. Yeah, okay, so this is where it's about to get good. The Commonwealth's next motion, the one that we're about to do after this 15-minute break, I believe is the relevant motion to what Hank wants to talk about when it comes to the federal investigation being over. So I think this is the motion where he wanted to bring that in as a point to the judge. I find it interesting if the judge says she got the federal protective order, because I know that they were trying to get her a copy of the federal protective order. But as far as I understand, that federal protective order was very clear that there was no prepping. There was no conversations to be had outside of court other than the problem is I can't turn it down. It's on my Beats headphones. I mean, it was behind me. That might be why it's a little bit.
You can turn it down. StreamYard function.
I did. I tried. It won't let me because it's on my Beats and not on the computer. I did the settings already for it. I looked for like 10 minutes. Went into the audio and then it just it doesn't have an option to turn it down. I can reduce the background noise, echo cancellation, stereo audio. Hold on. Let me try this. Is this better? Is this too high still?
You've got to keep talking because we can't.
All right,
when you just do this better, we don't have anything.
How about this? Is this better? Better? Lower? 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 Lower?
There.
Right here?
Right there.
Okay.
Because what's happening is that when you get loud, it maxes out your mic.
Yeah.
Yeah, it's because it's so close, and because they're like what I got these Beats for Christmas like 2 or 3 years ago. My husband got them for me, and they are like magnetic. So they tend to like go closer to me than I want them to be. But I do love them. They're awesome. These Beats. All right. Let's see. I moved. Is it still too high?
No, you're fine now. You're fine
All
now.
right.
Just keep your voice. Don't get real loud.
I can't help it. I might as well turn it down just a smidgen because I am a loud person. You can blame the Spanish and Irish in me together. All right, I'm going to leave it there. And if it's too high, you guys can tell me and I'll turn it back down. But no, we're not still on ARCA. The judge, I found that you guys saw that part, right? Did you see that part, Voices, in the beginning? Or did you miss that part?
I was
okay.
I didn't get here till I came in and said hello.
So in the very beginning, the judge wanted to ask some questions of Alessi about the defense. And she started by telling the defense, the entire defense, that there's been a lot of basically like blaming of this person didn't know and that person didn't know. And Yannetti wasn't on the emails and Mr. Alessi just joined. And she said, I want to make it clear that the defense is one and the same. And you all know, per the rules of the court, when one of you speaks, you speak for all of you. All of you.
Are you going to go mail that?
Like that's apparently
mail, regular mail. They'll get it in a couple days. It's right in Florida, right? It's going to. Is that the address?
I got
Elise, mute her.
I did. I did. Yeah, that if one of them speaks, you're speaking for the whole entire defense table, like the entire defense table. So you can't say like, oh, Yannetti wasn't on the emails. What you state to the court is for the entire defense. Like that's what you're representing. So you can't say you didn't know. Like it's your job to know. So you can't make the excuse of I didn't know Mr. Yannetti was on the emails. I just found out about the ARCA payment. Like all this excuses that they give. So the judge said, I want to ask a few questions, right, about it. And she started off by obviously asking some questions about it. Problem with it is that Alessi just gave more excuses. Well, Your Honor, I didn't find out about the payment until I think he said the 2 days before, like 2 days after the 16th or whatever, because she pointed out they all signed that motion where they said that the ARCA witnesses were not paid for or hired and they were neutral. And she's like, you all signed this, Mr. Alessi. She's like, yes, Your Honor, but I didn't know about the payment until it's your job to know. So like, that's the rule. If you're all going to act as defense counsel, one of you does something, you're all responsible for it. That's the way that it works. And so she started to ask questions of Alessi. The problem with it is he kept making excuses, just like she pointed out in the beginning, like there's no, you didn't know. Uh-oh. Hold on. All right, they're back to the, all right. There's no, you didn't know. You can't say you didn't know. Those are the rules, right? So, especially when you're practicing under another attorney's license, like Mr. Iannetti here has 3, count it, 3 Pro Hoc Vice attorneys under his license right now from out of state. When you say you're having them come here and practice on your license, you're agreeing to the fact that you are responsible for anything that they do or say or don't do or don't say. Like, you are responsible for them. So you can't just be like, I didn't know, Your Honor, you can't do, that's not a thing. So like this whole Mr. Iannetti, I think that really pissed the judge off. Like I said last time, you're insulting the judge's intelligence. So at one point, Alessi's just, word salading the court again, and the judge stops and the judge goes, you know what? We're done with this. We're going to move on to the next motion. And she got sick and tired of it because she knew any other questions she wanted to ask to get answers to, she's just going to be lied to, right? Making excuses and lying. Like, I believe she made her, like, her mind was made up about what she was going to do with all this before he did his 4-hour word salad last time. She had looked at everything. She already knew. She didn't actually have to hear from the defense. Like she said, I don't have to hear from you. If you want to be heard from, I'll hear from you. But I don't think, like, all he did for 4 hours was talk about absolutely nothing, shoot himself in the foot numerous times, argue against his own arguments, and insult the judge's intelligence. Like, lawyering 101, dude. Don't insult the freaking judge's intelligence. Like, come on, man. It's just not smart by any stretch of the imagination to insult the judge and her intelligence into what she can see in front of her. You lied. And let's point out that the defense then filed a motion, well, not exactly a motion, but what they filed was like a correction. They filed a correction. I think it was yesterday or the day before. They filed a correction to the motion they just filed saying that ARCA was not paid. They filed a correction to that now, which is like too little too late to file a correction. Now you're really insulting the judge by still throwing on this whole, we didn't know, the bill came out of nowhere. Like, no one, and I literally mean no one, believes that. Okay? The bill didn't come out of nowhere. Okay? Like, stop it. I don't know, did they? Was there 2? I saw the 1. There might have been 2. I could have missed it. It's possible. It is possible. I was very busy yesterday and Sunday, but I did see it, the first one, and I was like, "Is this real life? Are we really doing this? That's what we're doing right now? Like,
that's
what we're doing?"
Absolutely insane. That.
So you missed it, but she like shut him down basically, and was just like, "All right, we're moving on to the next thing." Like, she didn't even want to ask any more questions, and it was clear she had other questions, but like, she knew she wasn't going to get the correct answer. She knew she was just going to be lied to, so she was just like, "No, we're moving on to the next motion." Like. So it's like, uh-oh, like she gave them a spanking walking in there. So when you get a chance, you got to go back and watch it again. Actually, you know what? While we're on this little short break here, I think she said 15 minutes. I'm going to play the very beginning of what she said because I think it's important for everybody to hear what she said, like, to them. It's hard to hear though, so you might have to like turn the volume up on your computer because at first, I don't know if she's not in front of the microphone or if the camera's just not aiming at her, but like you really can't hear at first what she's saying. All right, let's see. God the fan was there for a while. Okay. It's right around here-ish where it starts to go to the judge. Zoom in on the fan. All right, I know at one point they stopped the zoom into the fan though. Hold on. Jeez, they looked at that fan for a long time. Jeez. Oh, all right. I think I found it.
22-117, the Commonwealth versus Karen Reed. Can I please identify yourself for the record?
Good morning, Your Honor. Barbara Laughlin, for the Commonwealth. Good morning, Mr. Laughlin. Good morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Good morning, Mr. Brennan.
Good morning, Your Honor. Alex Jackson, the street.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Mr. Hill.
Morning, Your Honor. Robert Alessi for Ms. Reed.
Good morning, Mr. Bessie.
And good morning, Your Honor. David Kennedy for Karen Reed.
Good morning, Mr. Nettie. Good morning, Mr. All right, so we've got a few things to cover today. We had a couple of questions to finish off about the defense position on the opposition to excluding the ACCA witnesses. Then we'll go on to defendant's motion to exclude Mr. Crosby, Dr. Crosby, and then we'll go on to the defendant's motion to exclude Robert Gilman. I know they're both under dogger grounds, and we'll hear about that. And the Commonwealth's motion for sanctions. And we have newly filed a motion to amend the scheduling order so that we don't hear the motion to dismiss today, and in opposition to that, and a motion to reconsider part of my prior ruling regarding the tapes of the Canton Police Station video. So that's the order that makes sense to me to finish up what we already had scheduled last week before we cover anything else. So the questions that I have before we start, so I want it to be very clear, counsel knows this. There has been some attempt at distinction between defense counsel. Mr. Yannetti wasn't on the emails. Ms. Little wrote the pleadings that everyone signed. Mr. Alessi's late to the game here. But you all know that when one of you speaks, you speak for the entirety of the defense team. When one of you acts for the entirety of the defense team. And when one of you makes representations or misrepresentations, you speak for the entire defense team. You know that. Do you understand that, Mr. Yannetti?
I do, Your Honor.
Mr. Jackson?
Of course.
Ms. Little?
Yes.
And Mr. Alessi?
Yes, Your Honor.
So each attorney is legally accountable for the actions and statements of the entire team.
Mm-hmm.
So now the questions that I have, Mr. Alessi, that you said, welcome questions, and I appreciate that. So I wanted to talk a little about that pause email that you call it. Could you stand, please, because I need to over this.
Yes, I was going to go to the podium.
Sure, go ahead to the podium.
Thank you. I didn't want to stand when you were talking.
You could stand. All right, so the pause email is you call it. So first of all, we have that Wednesday, March 20th, 2024, 10:49 a.m. Email from Mr. Jackson. Dear Dr. Wolf, thank you so much for taking the time to get on the phone with me this morning. Pursuant to our conversation, please feel free to forward an engagement letter to this email address. You will get that countersigned and returned to you forthwith, along with your retainer as required. Also, if you could attach a copy of your, Dr. Rentschler's, and Mr. Klein's CVs, I would appreciate it. I look forward to speaking to you and your team soon as we iron out the logistics for your participation in the trial. Thank you again, AJ. Then, as you pointed out, 2 days later, an email from Daniel Wolf to Mr. Jackson regarding Reed engagement, and that's the title of the other one. Subsequent to our conversation on Wednesday, the U.S. District Attorney's Office has asked that we pause on any further conversation until we receive additional information from their office regarding our involvement moving forward. I will provide you an update when I have it. Thanks, Dan. You called that a pause email, but when I was looking through my notes, what you said was, based on that pause email, I infer that there was no further discussion between ARCA and Mr.
Infer.
Jackson regarding.
I don't actually know.
Retainer, and then out of the blue, the bill arrives. So my question to you is, are you inferring or do you know that to be fact? That there was no conversation, emails, texts, letters, phone calls? Do you know that to be fact? Or is that what you are inferring, as you said?
I am inferring, Your Honor, I do not know that as a fact.
Ouch.
So now my next question is regarding the invoice and the payment or fact of payment. So the invoice was provided on February 13th, 2025, provided to the Commonwealth. The bill itself was paid on July 25th, 2024. Why wasn't the record of payment produced at the same time?
Same time as what, Your Honor?
As the invoice?
And you're referring to the record of payment being?
Yes, why wasn't the fact that this payment was made? It didn't come out, for me, at least for the court, until I asked you midway through your proceedings. And in fact, I have the opposite. I have filed after that February 13th date, and I know Ms. Little filed something yesterday to clarify this. Seems pretty clear.
Yeah, it is clear.
This was filed, I believe, on the weekend, February 16th. In the Commonwealth's opposition, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA, the Commonwealth's motion to exclude these exculpatory expert witnesses who were not hired or paid for by the defense is not made in good faith in a desperate and transparent attempt to keep exculpatory testimony of neutral expert witnesses from reaching the jury in this case. Going on to the next page, ironically, the Commonwealth accuses the defendant of failing to comply with their discovery obligations while conceding that the information is not in her care, custody, or control. Moreover, here, the defense has gone above and beyond its reciprocal discovery obligations and has already satisfied all of its mandatory discovery obligations under Rule 14 and turned over all additional information in the control and custody of the defense relating to the ARCA witnesses as ordered by the court at the last hearing, in spite of the fact that the defendant's reciprocal discovery is not yet due. How do you reconcile that? I had to ask you midway through your presentation whether that bill was paid.
I'm going to answer it, Your Honor.
They never were going to tell her.
I learned that invoice was paid Sunday night.
She just said not to do this.
February 18th. I'm going to repeat that. I learned. I'm sorry.
And again, what you know and what all counsel know is one and the same.
I understand, Your Honor. And I want to. So I'm answering your question. That's part one of the answer. When that was submitted on the 16th, I had not gone and done my investigation and gone through and asked all the questions
More excuses.
that I did.
So she's like
So
done
that's
now.
part one. Part two of the answer
Out
is,
of part
Your
50.
Honor, you've referenced that I didn't get to the payment until the middle of my presentation. The reason is because I did my presentation in chronological order. And that's the notebook that I laid out. I started with March, went all the way through. And when I got to the invoice, before I could state that it was paid, Your Honor asked the question, was it paid? And my answer was right away, yes,
It wasn't right away.
paid. And
It
I
was a
said,
pause.
and that's what I was going to get to next. So the reason why it came out when it did is because I did the whole presentation in chronological order.
But the motion, defendant's opposition to the Commonwealth's motion to exclude employees of ARCA is signed by you.
Your Honor, it is signed by me, but if
I didn't know.
could, with regard to 3.3A1. 3.3A1 is not a strict liability statute. That's the reason why it has knowing in it.
Such an idiot to argue
in
this.
order to violate 3.3A1, the attorney in question has to know with regard to the fact in issue. So respectfully, Your Honor, I have a different view of what an attorney is responsible for under 3.3A1. You're absolutely correct. Under
Dumbass.
everything else, particularly Rule 14, it can be no excuse for any attorney, including me, that I didn't know what was happening in discovery. That's not the way Rule 14 works. I am responsible for everybody.
Yep.
But Your Honor, it's clear in the commentary, it's clear in the case law. The reason why knowing is with regard to each attorney is no attorney can be responsible for the statements of issues of fact in court when it comes to a 3.3A1 analysis. That analysis and construction, Your Honor, would render mere surplusage and read out the mens rea of knowing. In something that critical of candor to the court, that's why they put the mens rea in, because no attorney can be responsible for a misstatement of fact of another attorney unless they have knowledge of the misstatement and they knowingly.
And you should have knowledge.
So I
It's your job
respectfully
to.
have a different conclusion than Your Honor does about attorneys being responsible for statements on candor under 3.3A
I'll
from
explain this
everything
after.
else in the world, which I agree completely with Your Honor.
This is where she's done.
I'm not going to ask other counsel. All right, so let's move on to the next motion.
Your Honor, if I could, the tags that I had, I marked them as exhibits. I didn't do that last time. The way, and I had to mark Mr. Brooks.
That's for the next motion, but she essentially stops it and says, I'm not gonna ask the other counsel. I'm not gonna keep asking questions. I'm done now, like, with this nonsense. It's 3.3A, where he claims that you can't be responsible for what another attorney knows or knowingly does or doesn't know. He's wrong, because when you practice under Pro Hoc Vice, you are practicing under another attorney's license. So when you do that, that attorney whose license you're practicing under signs this thing. You are agreeing when you sign that you are responsible for everything that those attorneys say, do, misrepresent, whatever. So he can go to 3.3A all he wants. He is a guest here in the Commonwealth under another attorney's license. When he was put on this case, it is his job to get himself up to speed and know everything. So you can't just claim ignorance and say, well, I didn't. No, it's your job to be up to speed on everything in this case. If you are going to be defense counsel, you have to know everything. Everything. It's your job. Like, that's how it works. Like, you're legally obligated. Like, so that's the judge's point, is you are legally obligated. All of these attorneys here, you can't keep pointing the finger at each other. Well, I didn't know, and this one filed this, and this one said this, and I wasn't on the email, and so we didn't know. And like, they squarely, I think Jackson has agreed to, like, take the hit. Like, if there's a hit to be taken, like, well, it's squarely on me because everybody wants plausible deniability. Problem with that is, like the judge said, anything you say, you're saying for the whole defense. Anything you do, anything you misrepresent, candor to the court. Like, you are misrepresenting, you're misrepresenting for the entire team. That's how it works, right? Like, so I find it funny that he continues to sit there and make excuses and argue against it, and then says, respectfully, I have a different opinion than Your Honor. She's the judge. You're, again, insulting her intelligence and challenging a judge. That's not very smart. That's not very smart at all. Like, I can't. I literally can't. And I hope the judge does give us an answer on what she's going to do with this, because I feel like we might not get it till maybe tomorrow. I don't know. I just feel like, hey, I don't think she'll give us an answer on it right now, although I think she's already made up her mind. I think she made up her mind before Alessi ever opened his mouth for 4 hours the last time. But I think she really needs to to give an answer as to what's going to happen, because that affects motions, that affects whether they have to hire a new counsel, it affects a lot. So instead of just going through motions every day this week, like, it's kind of imperative that she make a choice, whether she's going to sanction them, whether she's going to cut the Pro Hoc Vice, whether she's going to give them a stern talking to. Like, I just don't think a stern talking to is good enough for a multitude of reasons, in my opinion. One of them being, then you just invite this to happen in your court from attorneys from here and attorneys not from here who practice under Pro Hoc Vice. It just gives them like a license to come into your courtroom, toe that line, step over that line a multitude of times, and continuously lie and misrepresent, and this judge isn't going to do anything. And that's part of my criticism of the judge, is she allowed this to go on for too long. She allowed them to misrepresent, misstate, lie for way too long. I mean, way too long. If she had nipped it in the butt early on, I don't think they would have still towed the line, but I don't think they would have went as far, you know? And she didn't. She allowed them to just keep doing it. And most judges will stop you in the middle of talking and say, "Do you expect me to believe that? Come on now. Let's not, don't do that in my courtroom." Like, they will literally, like, you know what I'm saying? The chronic illness she is claiming she has, because at one point Karen was using it. Oh, so I think she has MS. I have fibromyalgia, and I know it's similar, like pain or whatever, but yeah, they try to use that. Like, I get brain fog too, but I certainly would know if I backed into somebody and hit them and left them to die. Like, that's for sure. Also, I got a $10 Cash App from Kathy. Kathy, I appreciate you. Thank you so much. I appreciate anybody that sends those, especially since we have to listen to Alessi, which is literally mind-boggling and makes me want to bash my head off a brick wall, as I'm sure it makes everybody else feel like, literally gouging out their eardrums. Because he says a whole lot of nothingness. So if you want to donate to the channel, there's a ticker at the bottom of the screen that scrolls by. It has the Cash App, the Venmo, and the PayPal information on it. We appreciate you. We do read the comments. I don't always read the name because I know some people want to be anonymous. But I appreciate anybody who steps up and donates to the channel, because my channel runs off you guys' donations. And a lot of smaller channels, like mine, you gotta cover costs first. So there's a lot of cost to be covered before you ever make a single penny, you know? And I'm telling you, if I hit the lottery, I'm making a thing for smaller creators to help them grow a little bit quicker than they do, to help them when it comes to like money wise, like, you know, give them a boost in money, like, so that they can grow, because it requires that. And I think smaller creators are sort of just skipped and left out when it comes to YouTube. We appreciate you, YouTube, but like, let's do something for the small creators. The big creators don't need help, right? They don't. So come on, YouTube. I'm telling you though, if I hit the lottery, that's what's going to happen, along with buying houses for the people that I care about and knocking on doors and handing out checks. I have big plans. Buying all the empty schoolhouses in my state and turning them into housing, turning them into apartments where people only have to pay their electric and their gas. Yeah.
Check the live. They're seating. They're
What?
seating. They're seating right now.
Oh, okay. Hold on.
Check to see if
It
you're
was
live.
already. What the hell? Oh, it's a minute behind. All right.
Is the Commonwealth's motion to impose sanctions pursuant to Mass Work Criminal Procedure 48. Mr. Leslie, do you need a minute? Did you need a minute? I saw you just.
Could I please just?
Sure.
Thank you.
Timmy?
Yes, I'm working this out.
Why don't I take a 5 minutes?
All right, please.
Oh. Another 5 minute. All right. Well, the spectacular talker, Alessi, you know, doesn't have anything to say right now. It's a shocker. It's an absolute shock, guys. I do. I mean, I've been here since 2023. you guys know I took a very long, months long break because of my kids' medical. So it's been spotty since I came back, but I'm trying to be more consistent. I promise. Eventually, I will get back to my regular streaming schedule, but right now it's going to be spotty at best. I try to give you guys as much of a heads up as I can. It's not always going to be a long heads up, but you guys can always get in touch with me, Discord, Facebook, Twitter. And these lovely ladies who have joined me have their own channels that you guys know about that you should make sure that you subscribe to as well. They have their own streaming schedules as well to check out their stuff. So make sure you guys do that as well. Make sure you put a like on the video. That always helps more people see it. I appreciate that. Share it. Share it on Twitter. Share it on Facebook. Share it on wherever. Share it on wherever. But yeah, actually, I was watching Unity's face in some of these when Alessi was talking and the camera sort of zooming in. And I'm like, damn, he looks extremely stressed out and worried, especially when the judge was sort of giving him the spanking in the beginning like that. The camera sort of panned into Unity's face while Alessi was talking at one point, and you could see it all over his face. Like, it's just, he was stressed the F out. Like, I mean, I find it funny that for the attorneys that Little basically never talks. It's very rare when she does. But for the attorneys like Jackson and Unity who like to grandstand, who like to talk for themselves, for them to not be talking for themselves right now speaks absolute volumes. And it's because they don't want to get caught in perjury. So they let Alessi speak for them. It's some sort of plausible deniability, but I think that's exactly what the judge was trying to nip in the butt earlier, which is Mr. Alessi is speaking for you. So, AKA, like, everything he says is going to be like the fact. And that's why she asked him, like, you said you inferred there's no more, that there's no more messages or texts. Are you inferring or do you know? And that, I infer. Well, you could just easily ask counsel, do they have any more or not, right?
Thank you.
He could have walked over to the table and said, is there any more? Said, give me 1 second, Your Honor, I'll answer that question. And he chose not to. For a reason.
As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense put the materials into the public domain despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, and given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public is that they create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial. There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing, There is no good faith basis whatsoever that that witness watched other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information of the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We just turned it over as a text message, and notice of discovery 51, a protective order was issued, docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So in considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours, it was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who is participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, the defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. there's been a ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with.
Did you see it? Ad Creative AI is offering 40% off annual plans. Don't miss this chance to upgrade your campaigns with
This recent protective order violation that got attention that money couldn't buy for a party. Other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on Court TV with Ms. Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is,
Where was that Court TV event?
I can get the date for Your Honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office.
Boom.
And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool.
Hammer.
Well, they become more egregious when you see that they're not based on reality of fact.
Nope.
And so
Where's Aiden?
I
I see his face
submit
for lying to people and he
that
knew he
the
was lying.
ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper and substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. what I suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts, so that we can have a trial on fact. There should be a gag order on all of these attorneys, every single one of them.
Yep.
And the Commonwealth will not speak either.
I knew he was going to do that.
I'm not asking for a gag order for it. And so in light of the history of these repeated violations, in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional,
misleading,
and obvious efforts,
misrepresentations,
in order to best try to maintain a fair jury in this case, is to impose those sanctions. And that's what I'm asking for. Thank you.
Mr. Nettie, you're arguing this yourself?
Yes, Your Honor. Please.
He's going to speak. What the hell? What just happened? Okay. Okay, well, I guess Nettie needed a minute, but boom! I'm just saying. I'm just saying. I told you guys last year when I confirmed it last year that this was over. This federal investigation was over. Ted Daniel found out at the exact same time as I did. He got the same exact information I did. Okay? At the same time. He confirmed this federal investigation was over last year. The difference between me and Ted is that I told you guys. Ted said nothing. Shame on Ted Daniel. Shame on him. Shame on him. Ridiculous. All right. It has been over for a long time. It's been over. There is no investigation that has anything to do with John O'Keefe. Not really, and that is why Hank made it very clear. Nothing related to any of this case at all is ongoing. It is done. It is over. Hey, cult, I'm sorry. Your leader lied. When he tried to tell you the other day it wasn't over and he confirmed it, he knew he was lying. He didn't confirm shit with anyone. He just needs it to still be going on so you guys consistently donate your money to him. He needs it because he looks like an idiot without it. It's been over for a year. They found nothing. And I told you this a year ago. What did they find in those over 3,000 pages and even more that the feds have themselves? Mean text from Proctor. That's what they found. That's what they found a problem with. That's it. Literally it. Like, oh no, they said no comment. And I want to point out that if it wasn't over when the Christina Rex asked him, they would have said it absolutely is not over. It absolutely is ongoing. Instead, they said no comment. I don't know how clearer Leah Foley could have been the other day when she went on that radio program and said, I am bound by the rules that I cannot confirm or deny the existence or ending or beginning of a federal investigation. But it is not unlike us to talk to our law enforcement partners And of course, everybody took a problem with the word partners, right? They said, oh, well, they're not partners. The MSP and CPD aren't partners. They are. So it can't be over. And then the sewer turtle said, it's not over. It's not over. I confirmed it with very reputable sources. It's not over. He knows that that is a lie. He didn't confirm it with any sources because it's been over for a year. You can go a year back and watch my live streams of me telling people the only thing they found was mean Proctor text. That's it. That's all they found. It was over.
Thank you, Your Honor. And may it please the court, Your Honor.
Hello.
As I mentioned at sidebar, I intend to make less of an argument here and provide more of an explanation for the content of my motion regarding the reciprocal discovery. And at the outset, as I mentioned in court last week, this was indeed my motion. Mr. Jackson's name is listed first only because I used a template for the signature block, and that's why I'm addressing this today.
Irrelevant, but okay.
And regarding the motion itself, I do acknowledge that I did not file a motion for impoundment when it was filed. And to the extent that that lack of impoundment is not congruous with the protective order,
yes,
it was neither intentional nor willful. It was an oversight, not an attempt to flout any rules of this court. And while I do ask the court to take my word for that, I do also submit that there is evidence to back up that word. Specifically, I would note that one of the examples I cited in the motion deals with the testimony of a juvenile. And when discussing that testimony in the motion, I made sure to use initials, not full names, so as to protect the juvenile's identity and to comply
That's irrelevant.
with the court's protective order.
That's
evidence
a different rule,
I
too.
did not intend to violate the protective order.
That's not evidence
and
of
that
anything.
I was mindful of it in that instance.
Yeah, and you still ignored it.
Caring for my daughter at home has become so easy since I discovered Entire Care. I'm compensated $1,500 per month.
That topic to the protective order when I was drafting it just did not register with me. It got by me. When I read Mr. Brennan's motion, I went back, looked at the protective order, and then it sure did connect with me. So I immediately called him, and I was transparent with him about what had happened. And so we get to the issue of whether sanctions are appropriate, and I recognize the court's discretion in this regard. With regard to this issue, I believe it is worth underscoring Mr. Brennan's reasons for seeking the protective order in the first place. He listed 3 reasons for the protective order when he filed the motion. And I quote his reasoning here. This order is necessary to effectuate the well-established privacy and safety interests of witnesses and to protect the integrity of ongoing investigations. So the Commonwealth sought to have this court issue the protective order to protect, number 1, privacy interests, number 2, safety interests, and number 3, preserving the integrity of other investigations. And I submit, Your Honor, those interests are all laudable. And I respectfully submit that my disclosure here did not undercut those interests. Regarding any privacy interests, Michael Proctor's opinions about Karen Reed and her attorneys have been well established and was well-known public knowledge as a result of the first trial. His opinions about my client and me were publicly aired at trial when his other text messages had come to light, inadvertently revealing that he feels the same way about Mr. Jackson that the public already knows that he feels about Ms. Reed and me is a disclosure, mistakenly, that should be considered in light of the circumstances that already existed in the public domain, I would submit. And while the protective order covers this communication, I will note that it was certainly not an instance where I, flagrantly revealed or even inadvertently revealed social security numbers, addresses, dates of birth, private information to that effect. As for safety interests, which was the second reason for the motion for the protective order, revealing that Mr. Proctor has opinions about Mr. Jackson does not jeopardize or otherwise implicate his safety. I would submit at all times during this investigation, and to the best of our knowledge, Michael Proctor is still a Massachusetts state trooper, and he's already on record with his well-publicized opinions as a result of the first trial, again, about Karen Reed's attorneys. So further information coming to light in this motion that he feels the same way about Mr. Jackson that he does about me does not move the needle, I would suggest, toward jeopardizing his safety at all. And finally, with regard to the third reason for the protective order, I revealed no information about any other pending investigation. In this message, Mr. Proctor was strictly discussing Mr. Jackson. Mr. Jackson does not represent any other individual that Mr. Proctor or the Norfolk DA's office is investigating. He represents Ms. Reed. And so that message from Mr. Proctor was strictly about this investigation and no other. So, in conclusion, Your Honor, I told the court I'd be brief.
Yeah, that's brief.
Protective orders serve important and laudable purposes, and attorneys, including me, need to be diligent in abiding by them. I exercise diligence in abiding by the protective order, but this communication got by me. The court will obviously determine the matter, and in making that determination, I simply ask that the court consider the interests of the protective order that were laid out by the Commonwealth and discussed by me here.
Yeah, and you can't follow it.
And as well as
Sanctions, thank you.
a degree of prejudice that would warrant a sanction.
Yeah.
Do you want to address the disclosure of grand jury minutes?
I am prepared to do that. If Mr. Brennan is resting on his written submissions, then I can give my oral argument now.
Mr. Brennan, you already argued this, right?
I did, and I do have concerns about my ongoing obligations, so perhaps I could have a moment sidebar.
Sure.
Sidebar. He said sidebar. I heard the word sidebar. Sidebar.
I think we got a super chat. I think we got a super chat.
He said sidebar. He said sidebar. While we're at the sidebar, if you get a chance and you want to, and you like my content, and you like coming to chill for the hearings and hanging out with us, because we have an amazing, awesome community here. I love my community. I love my viewers. Please give the like button a hit, share it with your friends, text it to people, that fun stuff. And you can give a donation, which my channel runs off of just donations from you guys. You can do so on Cash App, Venmo, or PayPal. The stuff it scrolls at the bottom of the screen, but people always tell me, like, oh, put the big one up. I can't see it. I miss it. So I put the big one up from time to time so people can see it. For breadstick money, you'll get that joke if you go back to some of my old live streams, but a lot of my viewers know that one. I do love breadsticks and coffee. I made my own coffee today out of my Keurig. I did. But if you would like to give a donation so that I can get new eardrums from listening to Alessi, I think everyone needs new eardrums. You can do so with the information at the bottom of the screen. And I appreciate you guys. I love you guys. You guys always are awesome. And you always have great questions. I absolutely love when people come in here and ask a question and they don't understand something. There are no dumb questions when it comes to like the law. Like if there's something you don't understand, like something the way they're saying it, like the legality of it, what could happen next? What does this motion mean? What does X, Y, or Z mean in a trial? How does this apply to this situation? I will always answer it to the best of my knowledge and ability. I actually love when I get those questions because you're probably not the only one wondering. And so when I can explain it in layman's terms and not legal terms so that people can understand, I think it helps with people understanding how a trial works, what's going to happen next or could happen next when it comes to a trial or a motion, you know, and especially in this case, because it's such a circus, an absolute circus, them invoking the Sandra Birchmore case, which has absolutely zero to do with the Reed case, literally zero. There is nothing that has anything to do with the Sandra Birchmore case that has anything to do with this case other than the state police being involved too, and it's an unattended death. So the state police always take over unattended death investigations in the state of Massachusetts. That is how it works. So that is not, well, there's the same troopers or the same officers. Yeah, they're the ones who investigate unattended deaths. So common sense would say there's going to be a crossover when they investigate unattended deaths from one case to another. Like that has nothing to do with anything. I think go Hank. He did, if you're just tuning in now, tell the world, as I told you guys before, this was the relevant motion to talking about the federal investigation being over. It's been over for a year, and it's been over for a freaking year. This is not rocket science. I told you guys last year, Ted Daniel knew last year. Shame on him for sitting on it and saying nothing this entire time. That really aggravates me. It is what it is. But if mainstream media had spoken up, like I'm just little old me, right? I'm just little old Elise over here with my small channel. Like only so many people are going to see what I'm saying. And I'm not mainstream. I'm not channel 7. I'm not channel Fox 25. Like they might hear what I say and say, well, how would she know? Why is she credible? Well, anybody who has watched me since the winter of 2023, when I realized Karen was guilty, will tell you how credible my information is. Extremely credible. So, I mean, ask these wonderful people in my chat. They will tell you. When I can tell you guys things in advance, I do. Some things, obviously, I can't say. But I love when the cult, does the cult ever do this to you guys? I love when the cult asks, well, how do you know that? If you give me the receipts, then I'll believe you. Oh my God. If you have an actual brain in your head, it would stand to reason that I can't give you what a source gave me, nor am I going to put that out into the public, because that would be outing my source and where I got that information from, which I would never do. Ever. So it's just a way to deflect by being like, well, if you'll give me the receipts, then I'll believe you. I even had an argument with somebody, I think it was yesterday on Twitter, who said, I said, well, once Hank announces, you're going to believe him then? Well, if he gives the receipts, what receipts do you think Hank is going to have from a phone conversation with the U.S. Attorney's Office? What receipts? So that's the thing. Even Hank saying it in open court, they're like, nope, it didn't happen. It's still ongoing. It's definitely still, because he didn't show us a letter. First of all, even if he had a letter, only the judge is going to see it. You're not going to see it. The judge is going to see it. Okay? So we're still going to have cultists over on Twitter who are like, nope, it's still happening. We don't care what Hank said. La, 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 la. Like, that's what they're going to do. And it's like, bro, at this point, it's pathetic and it's sad. And you live in Delulu land, okay? Absolute Delulu land. It has been over. It didn't just become over right now. It didn't become over a month ago. It's been over for a damn near year. It has been over. Been over. They found Proctor texts that they didn't like. That's what they found. Oh, Hank lied. The feds are still coming. Yeah. All right. They'll be waiting until they turn into dust. Literally. Okay.
Life's full of coulda, shoulda, woulda.
Sorry, I should have muted that.
I could have hired a
My
plumber.
bad.
Should have locked the windows.
Should have kept the cult out. It's like, what's the source? Give us the source. Does it not amaze you? Because at me, I'm like, bro, yeah, let me just hand over my source or sources to you and where I got the information so that I can never get information like that ever again. I'm going to go with no for 500, Alex. No. Like, it's over. Put that in your juice box and suck it, okay? It's been over for a freaking year. Ask Ted Daniels. He's known for a year. It's like amazing to me, like completely amazing. They're not coming. The sewer turtle lied to you knowingly. He knew it was over. He's known for a long time. Stands to reason that if Ted Daniels knew, and I knew, at some point after that, he knew. He knows. And he certainly did not confirm with any sources it's ongoing, because it's not ongoing. So that would literally be impossible. If you don't think you're in a cult at this point, but you're still believing the words that are coming out of his mouth, even when it's proven to be false over and over and over and over and over, it's time to take a look at the person that you keep believing when they keep being wrong. The feds are not coming. They're not arresting witnesses or officers from CPD or the Mass State Police. None of that is happening. None. Zero. I'm sorry you're angry about it. I'm sorry you can't cope, cultists, but it's been over for a freaking year. It has been over. Yeah, that's another thing. They're gonna, like, dude, the witnesses are literally just witnesses, and they're not involved. Like, other than being witnesses, they were cleared by the federal investigation, which has been over once again for a damn near year.
Well, we all rose and then we sat back down.
Yeah, I was gonna say, I thought so too, freak. But yeah, that's exactly what happened. Voice is right. They sat back down. So I don't really know what just happened there.
The heck?
Oh, well, Anna, you just hold on to your hat and buckle up, darling. It's gonna be a bumpy ride because them civil lawsuits are gonna be hitting T-minus soon.
You think? You really think there's going to be civil?
No, I don't think. I know. I don't think. I know.
Oh, I believe there will be civil lawsuits coming out of this.
Could be.
No, I know for 1,000% certainty. There is no think. I know.
After the things that were done to them people, that's freaking.
There's going to be quite a few civil lawsuits, and not just from the witnesses or the family. You're going to see quite a few lawsuits coming from quite a few people to quite a few other people. Defamation, libel. Yeah,
it's all warranted.
It's legally strategic to wait on a civil lawsuit until, like, the case is almost done criminally, or is done criminally, if you can. Like, if you, because there's like a clock, you know, there's on some civil cases, like in some certain things, like you have 3 years from the date of X, Y, or Z to do this. So, like, you know, or 5 years, you know what I mean? I'm just using that as a template. You have a time clock on certain things for certain amounts of time. So you either wait until you get as close to the time as you can, if the criminal case isn't over, or you wait until the criminal case is over or almost over before you drop those civil lawsuits. So you will see those civil lawsuits fairly shortly. Oh, you have no idea I don't think people really understand the extent of what the witnesses, the family, and then extension, anybody who has publicly supported, opened their mouths, told the truth on this. You're talking about, we're into the, I think Michael Phelps said it best, we're into the over 100 or more people's lives who have been altered or permanently destroyed from this, and all for nothing. All for nothing. All for nothing. All for the cult to just keep sending Aiden donations and paying for him to be a piece of human waste. Like, that's essentially it. And to keep listening to all the lies that he tells on a daily basis to the point where he can't keep them straight anymore. And the amount of harassment and the amount of abuse people suffer to this day. Like, when I tell you guys that, like, I still daily get emails, text messages, DMs, like I don't even like. There's so many other things that they do on a daily basis. Like I literally at this point like laugh at some of them, but some of them like are so crazy that like you'll actually get like threats. People will start stalking you and then cyber stalking. Like it's cuckoo bananas, okay? And it has not stopped. It is not. We're in 2025. It's been happening since 2023 in my life, okay? Since 2023. We're in 2025. At what point do these people go, wait a second, I'm harassing a person I don't know and I've never met? Does that sound like a good idea? Yes, all for a woman who couldn't face up to her.
Bless
her
you.
responsibilities. Is
Yeah,
that
I
a
was
sneeze?
blown.
Was that a sneeze? Bless you.
Sorry about that. I was blown ashes up. But what happened? She told everybody to stay stood, and that's it. They left
I
again.
don't know. Yeah, I guess they stood up, sat down. I don't know. You know,
They do the hokey pokey and you turn
and they
yourself
turn yourself around.
That's what
That's
it's
what
all
the
about.
sidebar is all about.
Did you guys see my shirt? For those of you who didn't see my shirt today when I read it this morning, it says, I'm going to let karma fix it because if I fix it, I'm going to jail.
Yeah.
That's what my shirt says. I thought it was appropriate for today's hearing. See? Boop. Thought it was very appropriate for today's hearing.
Come on, Judge. We already, you know your decision. Why are you so hesitant to put it down?
So this is what I think is another criticism I have of the judge, which is I have never, in doing cases for so long, never have I seen a judge put so many things under advisement and not just rule on some things right there. You know, we got to wait until later on, until she writes it up and, you know, then it's on the docket and then we can read it. And it's like, there are plenty of judges who hear both arguments, look at what they have right there, take a recess, make a fucking decision and tell them. Like, I know, right? I think right? That's so funny too, because this morning when I was doing the settings, I was like, mirror or unmirror? Mirror, because it's automatically checked off on to mirror your image. So I was like, meh, should I keep it mirrored or unmirrored? I don't know. So it's like, bro, that's how it's recording right now. Like, it's not altered, that's how it's recording. Like, the fact that people don't seem to understand that mirrored, again, if you can't see my arm like this when it's mirrored, you still will not be able, like my hand, you still won't be able to see my hand if I unmirror it, okay? You still can't see what you can't see in the video. It's like amazing to me that people don't understand this. They seem to think that if like you unmirror it, they'll magically be able to see the taillight. No, whatever you can't see in the video, you still can't see. If you, the fact that anyone believes that is like, like I can't. Like, do you have any brain cells left? Like, what is happening? Voices is still here, yes.
Yep, I'm here.
She's here. What do you guys think? What do you guys think about the hearing?
I don't really have much to add other than I'm over this looking at the fan and Lighty McLighterson.
I know. I know.
Yeah, I'm just ready for her rulings because we all know she's already got her decision. So come on.
Oh, absolutely. I agree with you there. Abso-freaking-lutely, she does.
And I'm making chicken and apple sausage, so I like my stomach is rumbly tumbly, so I've got to put food in it really right now.
I know, I'm hungry too. Well, they don't even do lunch till 1, I think, in this court, which is kind of annoying.
It's almost an hour out. I couldn't wait any longer.
Yeah, girl, go for it. Oh, so I am getting some information right now that the sewer turtle apparently is streaming, and when Hank said that it was over, he said, sure thing, Hank. Way to be in denial, bro. Way to be in denial. It's amazing to me. Like, you think Hank made it up? Just FYI for the cultists, Hank can't make it up. He cannot put that on the record in court, knowing it to be false. He could lose his law license and be thrown off of this case completely and risk Karen's whole case being dismissed. Now, do you think that's something that he would do? No. Yes, exactly, freak. I'd like a ruling too in front of the court. So they can't flip it either. I would love that. And I feel like because she doesn't do that, it allows them to try to play gymnastics with the things that she says and try to like weasel their way out of what she's saying.
Exactly. She's I'm not surprised Turtle Boy's at it. I can't wait for his trials to start.
Oh, me neither. Do you think I have knowledge in this case? What? That one I have even more. I can't wait to see that spanking. I literally can't. Now remember what the Judge Krupp called it. Yeah, when he called himself a journalist and said it's his journalism and it's his First Amendment right, it's journalism. Judge Krupp in a
You've got a lip balm in every room, right? Because without it, chaos.
I know.
That judge should have never allowed him in the courtroom.
No.
Period.
I agree with that.
That was so
That's
messed
another
up.
criticism I have of the judge. He should still not be allowed in the courtroom to this day. Especially because of what he was doing lately with his computer screen to like harass people and intimidate people. Like he was doing it on purpose. We know that because we literally have the messages of him telling people like, check out what's going to happen on the 6th. Keep an eye on my computer on the 6th. And then claimed afterwards, like, I didn't know they were going to be looking at it. He knew. He planned it. We have the proof.
Exactly.
It was sent to the court. Like
maybe this time.
Who knows? He's not there, I don't think. I think he's streaming today.
The state, maybe this time will fight a little harder him being allowed in the courtroom.
I think, and this is just my opinion, but I think you'll find that Hank Brennan will file some sort of motion or ask the court when the trial comes to not allow him in. I don't think it's like it's pointless to do a pre-trial unless they caught him doing that stuff with the computer. At that point, he should not have been allowed in. He shouldn't have been to begin with, but once he was doing shit like that, he should have been tossed. But I do believe that Hank Brennan will wait until right before the trial and then argue why he should not be allowed into trial with the witnesses there because he has those charges and because of all of the things he's done since then. So I think Hank's just waiting for right before trial so that they can keep him up for the entirety of the trial. My God, you guys are making me so hungry. We're talking about burgers and KFC chicken sandwiches. I wish.
We're getting snow. Otherwise, I would have something good. Ooh, I should. Where is it? The bistro.
I wish. I need groceries, so I don't have none of that over here.
That's
probably why he's not in the court today. I think he could have been thrown out without telling anyone too. Possible that he was already thrown out, not telling anyone on purpose. What the just happened? Just said court's in session. No? I mean, what is happening right now? Yeah, I'm live. I'm up to the
Boston 25 is showing the same thing. So
so annoying. You just said court's in session. No? Like, what the hell? What in the hell? They just did that twice. Court's in session, court's on a break. Listen, I would love for the judge to just give us a freaking answer on something. Anything. That would be phenomenal. I feel like we will get some stuff, obviously, this week, but it's like, can we get it now? Can I get a witness? Can I get it now? This is redonkulous. Like, we just did a courts in session twice here. Twice. It's like, I don't know how long you're going to be on a break, or I would go back and play that part. I'm going to after, like, this is done, and play that part again about the federal investigation because it's important for everybody to hear it the way Hank said it. He said it that way on purpose. because then, the cult runs around and says, well, he said it's over, but there could be another one where they're going after this person, that person, this person. And that is why he said nothing related to this at all. There is no investigations related to this in any way, shape, or form. It is over. It is done. It is gone. Because he knew the cult was ready to spin. I mean, that's what they do. Hank Brennan cannot just put on the record that it's over and that he talked to the U.S. Attorney's Office if it's not true. He could Karen's case could be dismissed completely if that was found to be a lie. So, yeah. I mean, I can hear it in my head now. I'm literally thinking about what crazed lunatic arguments they could make, which is, well, how would the judge know if the federal investigation was over or not? How would they know? Well, I'm going to tell you this. If the defense thought that was a lie, they would have jumped up out of their chairs. They'd been telling the judge that's a misrepresentation. That is false. That's not a thing. Just remember that. Remember. You think the defense would just let Hank lie and not be like, that's a lie, Your Honor, that's a misrepresentation. He should be sanctioned. He should be. Stop it. Stop it. I wish. That sounds delicious. I like me a rodeo burger here or there. Rodeo cheeseburger, those are delicious. I'm not going to lie, their mozzarella fries are pretty good too. I haven't had those in a while, but they're really good. I hear you, Zen. I hear you. It's like, man, I want to know what she's going to do when it comes to the defense at this point. Are you taking the Pro Hoc VJ? Are you just going to give them a good spanking in open court to tell them that they're bold-faced liars? I believe at the very least, ARCA will not be allowed to be talked about as an independent anything or a neutral anything. That will be definite. I think, in my opinion, it'll be definite. They will not be allowed to say that, not by a long shot. I also do want to point out to people that just because a federal investigation is over does not mean that that is going to be talked about in trial. It won't be. It won't be allowed into trial. It could be prejudicial to the jury. It will not be allowed in. Just because it's over doesn't mean it's magically going to come in and they're going to talk about it. They're not. It won't. Just like the last trial, it absolutely will not be talked about. It won't be allowed in because it could be prejudicial to the jury to hear it. And in the first trial, the judge knew that it would be prejudicial to the jury because it might lead them to believe that someone did do something wrong. And then now in this case, since it's over and there's no charges, no one's getting, you know what I mean? Nothing happened, and it's been over, then the same argument would apply where the judge would say, well, it could be prejudicial to the jury that they would think it goes against the defense argument. So do not expect that the federal investigation will magically now be allowed to be talked about at trial or people to be questioned about it. They won't be. It won't be allowed in, just like it wasn't the first time, because it is prejudicial. So I wish it would be, because it flattens the defense theory completely. But that's exactly why it won't be allowed in. So it could be prejudicial to the jury. And, in the first trial, once again, it was prejudicial because you could infer by that maybe somebody did do something sketchy. And so that could prejudice the jury into giving a not guilty verdict when that really had nothing to do with anything, because as we know now, the outcome of it was nothing. So imagine a jury let her go, not knowing that in the end, the federal investigation was over, done, completely done, So, I mean, to me, I just want to see what the judge decides to do with sanctions. I want to see if she puts this gag order in. Hank asked basically for a gag, but not for Karen herself, just the attorneys. So it's like, I want to see what the judge decides for sanctions, because that will sort of give me an idea into what I think she might do when it comes to the defense in general. I think, and unless she waits to give both of the answers at once, which she may do, like what she's going to do with the defense and also what she's going to do about Hank asking for a gag. Well, she can. I mean, if I was Hank, I would have asked for a gag order for the whole thing. But he specifically said he was not asking for one for Miss Reed, just the attorneys. So I don't know. I don't know why you wouldn't ask for one for her, because then she's still going to just run her mouth. But again, if you ask them for the attorneys won't be allowed to give her certain things or tell her certain things so that she can then not disseminate it to other people. That was a long sidebar if that's what they did. Or maybe that's what they did.
Thank you, Your Honor. And thanks to the court for allowing me to make much of my argument at sidebar. The only remaining argument that I can make.
Come on.
We did that because that was material that needed to be done at sidebar.
Oh, I understand, Judge. And I'm thanking
want the record to be clear.
I understand. And I'm thanking the court for that. The only other argument that I'd like to make, and this is appropriate to make in public, because there were allegations that I believe, misconduct regarding the existence or non-existence of the federal investigation, specifically directed at Ms. Little. The timeline is important here as well. Mr. Brennan himself was provided and sent a letter on January 30th of 2025. The letter was directed to him specifically. We obviously received a copy of it. And in that letter on January 30th of 2025, the first assistant U.S. attorney, Mary Moraine, informed Mr. Brennan that the federal investigation was ongoing. Those are her words. Mr. Brennan knew that.
No, they didn't.
It was after that letter, I think within about 3 weeks, we were in this courtroom, and Ms. Little had mentioned the ongoing nature of the federal investigation. Not only was that truthful, that came from the horse's mouth. It came directly from the U.S. Attorney's Office, and
no, it didn't.
Mr. Brennan was aware of that because he personally got the letter. It was only after that Mr. Brennan has reported to the court that the federal investigation later was closed.
Can you give me dates again, please? So what was the date that Ms. Little made that statement?
Hey, Otter.
And what was the date that you all found out about the witness you had just announced?
He's a liar. That's not what he said at all.
January 30th was the letter. We believe February 18th, when we were before this court, was when Ms. Little made that statement. And then it was thereafter. I can't speak to when Mr. Brennan says that the federal authorities contacted him, but it was after February 18th.
When did you hear the information?
I want to see the meltdown. People send me texts.
That Mr. Brennan just told us.
Mr. Brennan called me to inform me of that.
When?
I don't remember the date. Maybe, perhaps he can tell the court when that was.
Was it prior to February 18th?
No, it was after.
You've got a long to-do list.
Damn it.
Thankfully, you have DoorDash. And top-rated shoppers will deliver groceries right to your door as if you picked them all yourself.
Come on.
Put your groceries in good hands. Order all your groceries with DoorDash.
This was not a boogeyman. The federal investigation existed. It was confirmed to have existed multiple times as late as January 30th. And it's right there in black and white.
No, it's not. That's not what it says. It doesn't say it's ongoing right now. No, it doesn't. Go ahead, Hank. Tell them.
Ms. Little made her argument on February 18th. The Norfolk County District Attorney's Office was contacted about 24 hours later on February 19th. I gave written notice and called Attorney Yannetti on February 26th. The import of the argument is not that the defense was aware it was closed and continued to persist. It is insinuating and suggesting for years of this amorphous impropriety. It is trying to bootstrap their arguments, claiming, yes, that there's a boogeyman, that something is happening in the federal court, but they can't talk about it, when the reality is now that that case is closed.
If I may just briefly respond to I'd like the court to take particular care, but when we're talking about extrajudicial statements, not to take into account statements that were made in advocacy in court to Your Honor. The
What?
Commonwealth referenced a statement that I had made regarding the federal investigation. That was in a courtroom setting. It was not an extrajudicial statement.
Also, under the umbrella of the rules of professional responsibility.
Correct.
Correct. He was not within the courtroom.
Okay. Thank you. So what I'd like to do now, there are new motions that were really just filed. And what I'd like to do, I have one that has a response.
I'm dead. This is funny.
So it's the motion to amend the scheduling order to give the defendant a little bit more time for their motion to dismiss and the Commonwealth's opposition. I would like to hear that now. We need to give.
Yep, let's hear it.
The parties have any problem with hearing that motion now, or is a
No, Your Honor, I think it's very great.
motion? All right, so I need 1 minute to see that. Can you write it to the rules from this morning, the new ones?
Can't hear it. What the fuck are you saying? Speaking to the microphone.
All right, so you're both prepared to argue this motion, right? The motion and the opposition?
I'm so sorry.
So both sides are prepared to argue this, the motion to amend the court scheduling order?
Yes.
And the opposition, is the Commonwealth prepared in the opposition?
Your Honor, we filed an opposition and just informed defense counsel if they're looking for a date this week if the court's available. I just don't want this to linger because.
So I'm happy to do that. The 17th is out. It's way too far away. But I will hear you. I know what I think is a reasonable date, but I will hear you to see if you need more time than what I think is reasonable.
I'll agree if they need a few more days without opposition.
Given that, may I, speak with counsel? May I address the court, Your Honor?
Okay.
Thank you. Very briefly, and I appreciate Mr. Brennan's accommodation. We received on Friday about 400 pages of new discovery, including most of it is probably not attendant to the motion to dismiss, but there are several reports, I think about 4 reports from Trooper Buchanan, Officer D. Jim Petro, D.I. capital G-I-A-M, P-I-E-T-R-O, and 2 reports from Lieutenant Tully that are specifically attendant to the issues involved in the motion to dismiss. And then last night we got additional videos, video evidence, both 9 videos of the download process of Sally Port videos, and then about another 15 actual videos. I basically.
What's the quality of those videos? Are they poor quality?
I wish I could tell you. One of them came in, one of the batches came in after I was already asleep last night. I think it came in probably 10 or 11 last night, and I didn't see it until this morning. I've not looked at any of them.
Has anyone on the defense team looked at them?
I know Ms. Little was.
Yeah, I briefly looked at them. It took about an hour last night at 9:30 p.m. to download everything. I cannot represent to the court that I've gone through in detail. I saw what was there. I'm generally aware there are about 8 videos that were produced of them filming themselves dragging files that cut in and out. There's about, don't quote me on the exact number, I believe approximately 9 videos from the Sally Port garage, maybe 12. I have not watched it in detail.
But have you noticed the quality? Is it something that you can actually see, or is it blurred and?
I think some of them are at least the same ones. Some of them I think are blurry. I haven't watched them all in detail. I can tell you that they have the same file names as some of the ones that are produced. They have different file sizes, but I haven't gone through them in detail. It was 9:30.
All right, go
So-
ahead, Mr. Johnson.
Your Honor, just to close, I think that if I have overnight this evening, I think I can be ready by tomorrow. I'm generally ready. I just want to make sure I'm not missing anything, leaving anything on the
So
table.
what I was thinking by way of scheduling, we've gone through just about everything we need to go through today. I just wanted to, because it's about scheduling, what's the Commonwealth's position on Ms. Little's, I assume it's Ms. Little's motion to filed by Ms. Little motion to reconsider my previous ruling on the videos? Do you want time to file something on that? Are you prepared to argue that today? Because I can tell you the options that I have for scheduling.
We've already downloaded the videos and provided them to yesterday pursuant to the court's directive.
Okay, so that was going to be another issue that I had.
I have not looked at them, Attorney Riley did, and he represented that they're all the videos we've already turned over, same quality as we previously provided. They're just copies of the same videos, although they do want to make sure the defense has an opportunity to examine them for themselves. But those have all been done, so the idea of revisiting that, we passed that.
All right, so in order to keep moving this case forward, because I know how hard everybody's worked, what I was going to propose, based on my review of this, because I could just say no, which I'm not going to do. I would like anything that the defense is going to put in writing. If you're going to supplement this, and I would keep the supplement just limited to the Sally Port video and related evidence. That has to be filed by Thursday with the idea that we will have a hearing on this on Friday. We have Friday already blocked off. This way here, you can all leave for today. And we'll come back Friday with this. But I'd like it filed no later than 2 o'clock on Thursday, Massachusetts time. We've been getting things coming in later, including something from Ms. Giannetti after 5:30 one night. So we need things filed by that court day.
By the end of
So,
court.
you can have anything that the defense wants to file by 2 o'clock Thursday, and we'll see you all here for it how long do you think it'll take to argue the motion to dismiss?
Your Honor, I would expect my comments, just based on what I have so far, an hour plus, perhaps an hour and 20 minutes, something like that.
Okay. Commonwealth's response, any idea?
Of argument time, Laura?
Yeah.
It really depends on what the defense argues, but it typically is less.
So if we start at 11, we'll finish Friday?
Of course, yes, I believe we will, for sure.
How does that schedule work for people?
It works for the Commonwealth.
Right. I need to ask this one quick question.
While he's asking her that, that would mean that we do not have to appear tomorrow.
Right, you're in federal court, I want you to be able to
Thank
go do that.
Thank you.
And not have to come back here tomorrow.
Yeah.
And I'm trying to consolidate this now so you can leave it half a day today, rather than coming back. I'm just trying to make the best use of everybody's time.
Much appreciated. Your Honor, 11 o'clock would work. I think I can make my flight. By the time we get done, I can get to you. That's fine.
All right, so where do we stand in the motion for reconsideration? Sounds like the files have already been provided and it's done.
Your Honor, we still would like to be heard as to that, obviously. We gave notice that we were seeking a motion for reconsideration on Sunday night. They did the download Monday morning after they received that. There is still metadata, we believe, on the Camden PD drive. I think we're entitled to that. I think the law is clear. I would like to be heard on that issue. Obviously, we can't take back what they did. They have moved the files, and by doing that, it does alter the metadata, as our expert declared his affidavit. It may be lost, but we'd still like to have as much information as we can as it relates to those files.
So how long does the Commonwealth need, I know this motion was just filed, how long does the Commonwealth need to be prepared for this motion regarding the metadata specifically?
I think we'll file a written response.
Okay.
So that'll be a couple of days.
Okay.
If we have motions, we'll make it Friday.
Yes.
So I think I'll make a motion in writing, but I think we will hope to have the weekend if the court allows, because with all of these hearings, it's taken away quite request of the doctor.
Alright, can you argue it on Friday and file a supplemental afterward?
I can do that.
That way then we can have everybody here Friday and I don't need to bring everybody back on Monday.
We can do that now.
Your Honor, I would ask for the same courtesy for the defense. We have
No.
all of our reciprocal discovery due on Thursday. We have all of our motions in 1 week
No.
on Friday. I know the court would like us to.
No, you don't get the same courtesy because you had plenty of time. You're supposed to file it 2 weeks ago. That's why, no.
But I would appreciate a little bit additional time as well.
No.
So I need to know how this affects the motion to dismiss though, right? I need to, you've had this since, so you've got these recent ones, but I need to know how that, are you going to argue that in the motion to dismiss?
Well, I don't know because we got it last night at 9:30, so I wish I could answer that for the court, but I'm in a bit of a catch-22. It might be irrelevant, it might not be needed at all. I won't know until I have a chance to actually go through everything.
No. Say no, Your Honor. No.
Right, I need to make it Thursday. It doesn't have to be a complete report, an outline even, would the Commonwealth be satisfied with an outline?
No.
You know what the points are?
And I'll let what you are.
Of what Ms. Little says, how.
The fuck is that noise?
What is that noise?
I don't know. In the court.
Sure, we'll deal with it.
All right, so if you just so that I know the points that you're raising for the motion to dismiss, and then I want to supplement it very quickly thereafter. I have to decide this and put something in writing. So I need it to be done as quickly as possible. We've got a team of lawyers. I know the lion's share of the writing appears to be on you, Ms. Little, but there's everybody here that can help.
Yeah, 1 minute.
We shouldn't have given them any more time. She gave them an extra week already on that motion to dismiss when she shouldn't have. The thing is a joke anyway. It has no legal teeth or merit anyway. They can claim it's good faith basis. So I guess legal merit, but it doesn't have legal teeth.
I take Mr. Lally at his word that the new videos are duplicative of things that we already have, which means it's not going to make any difference whatsoever. Could I ask the court if it's okay with Mr. Brennan? We can be here tomorrow afternoon, tomorrow late morning, right after the federal court proceedings. Let's just argue this tomorrow. I will concede
this. What?
The motion to dismiss. I think I'm pretty much ready now. I can be ready by tomorrow. I need to add a couple of things about the new reports, but if the videos are the videos, then I don't want to wait. I don't want to waste the court's time the rest of the week just to come back and say, okay, well, basically it's the same thing. It's the same argument that I would have made today or tomorrow. So I think we can do it tomorrow.
He knew he'd be in trouble if he asked for extra time for it to be the same. That's why.
The additional argument that Ms. Little says, are you saying now that when Mr. Lally told you that, you accepted and that's fine?
I accept his representation is true, and I don't think that we need to file a supplement, which is really where the hang up is. I don't think we need to. If the videos are the videos, we don't need another supplement.
All right.
He knew he'd be in trouble. He knew he'd be in trouble if he waited another week and it was the exact same motion. The judge would have just said they were delaying and they would have gotten in more trouble.
But didn't his co-counsel just stand up and ask for more time?
But if we need additional time, we can certainly let the court know tomorrow.
Okay.
That we can file something supplemental. But the crux of the argument can be made tomorrow. I will be ready to argue tomorrow.
Okay, what's the Commonwealth's position?
I'll defer to the court. I know it's more complications with defense and travel will be available now.
So I think we did log off today and tomorrow.
Yep.
With the understanding that the defense team would not be here until sometime 11 o'clock or later. What about Ms. Little, the motion regarding the metadata? Commonwealth needs time for that. Are we coming back Friday for that?
That's fine, Your Honor. I'll be here Friday.
If you're going to be here on Friday.
Not what she wanted to hear.
So if we do the motion to dismiss tomorrow, I can head back tomorrow evening. And Mr. Little will handle her motion anyway.
I greatly want to accommodate the defense as we have the entire time I've been here, but we have trial prep to do as well. In more court hearing days, we have hours of conversation, the more time we can
meet with witnesses and prepare our case. And so I want to make things as easy as possible. That's I do.
All right, so Ms. Little already filed the motion for me to reconsider. Why don't we hit that tomorrow?
Very well.
Okay,
Yep.
and then we'll just finish up everything tomorrow.
Good idea.
All right. All right, and then you won't have to be here Friday, but the motions in limine are all filed. It also involves filling out a final trial conference report.
Understood.
So we need to do that as well. That all has to be done by Friday.
Understood.
And then, you know, my goal was not bring you back one day at all next week, because then we're gonna have a full hearing, I believe it's the 18th, on the motions in limine.
That's right, the 18th.
All right, so you have a whole week next week to, you and I both,
Okay.
trying to get everything done.
Should we file a formal motion to ask the court's permission for delay from Friday till Monday?
For the,
Motions in limine.
the Commonwealths would do on, the defense would do on Thursday, Commonwealths on Friday. Yeah, they're all on Friday.
Reciprocal discovery is due Thursday. We want that to happen. Motions in limine, I believe, are due Friday.
Ms. Little, would you like the weekend for all those motions in limine?
I would appreciate that, Your Honor.
All right, I'll give you both the weekend.
Thank you very much.
Motion in limine to be filed on Monday.
There's one additional housekeeping, Your Honor. There is also a motion pending, the dollar motion for Dr. Wolf. It has not been heard yet.
A Daubert motion for?
Dr. Wolf is a neurologist. So there's
Oh,
one
I
additional.
I was thinking the archivist.
No, Your Honor, it's the neurologist, so the Commonwealth. We'll put that in WOLF. That was filed, 2 weeks ago.
I have not seen that.
Okay.
Is Alan Jackson doing shots?
I'll make sure that the court gets it.
Oh, no, but he looks rough.
I know that was filed several weeks ago. I'll confer with Mr.
The Commonwealth must have received it.
We did. We have a Wolf as well, and I received their Lanigan motion, and we'll be prepared anytime to argue that.
Do you want to argue it tomorrow?
I'm probably comfortable arguing tomorrow.
We're prepared.
All right, so we've got an awful lot to fit in tomorrow. All right. If you get word that you'll be leaving the federal court and can be here before 11, please let us know.
I believe I might have Mr. McDermott's cell. I'm happy to text him as soon as we're leaving the courthouse.
All right, just contact the clerk's office.
Sure. Okay.
Anything else for today then?
Not for the finish up. Thank you.
So I'm gonna give you all of the, why don't you put up all the percent of the application?
Court call, Riley, please.
Another nothing. Oh my lord. Why is she putting off making this ruling, laying this ruling down? What's up? Something's starting to get
So
stuck.
here's the thing. She almost never makes them like in court anyway. I knew that. Most of us know that. I do think here's the problem, and here's the problem that I see now. The problem that I'm seeing now is that she is doing scheduling for the upcoming week, giving Miss Little until Monday to do this, Jackson this day to do this. If she had plans to take them off,
What do you want to do today? What do you want to do?
then
I got
she
dressed
wouldn't
up. What do
be-
you want to do?
Not muted.
I got it. She wouldn't have planned on giving them more time, on allowing them to have it till Monday on this and Friday on this. So I don't think, even though she should, I don't think she is going to take Jackson off because Little would have to go with him. If she was going to, I don't see why you would be scheduling all these things and allowing Little more time to do it Monday, blah, blah. If your intent at this point would be to take them off the case, then someone would still have to be responsible for doing all of that. And you wouldn't give the responsibility to the person you were removing, right? So my guess now is that she gives them a good, stern sanction talking to in court, in the public. And also she either doesn't let ARCA in at all, or she doesn't let them say anything about ARCA being independent or neutral in any way, shape, or form. Because right now, what it looks like is she's not going to take that step, and she's not going to remove them from counsel, which I think is really sad because it's an invitation to other attorneys to act this way in her courtroom and get away with it. She had a chance here to sort of clean up the mess that she made, allowing them to do this for so long and not doing anything about it. And this is what Hank pointed out earlier, which is she hasn't sanctioned them, okay, before, and she should have numerous times, and she hadn't. So I'm like, what in the actual F&F?
It's an invitation to let defendants act this way in her courtroom.
Yep. And that she's just going to do, like Bree's saying here, jack shit about it, because you can give them a stern talking to as a sanction all you want, dude. But literally for an attorney, it goes in one ear and out the other. Is it embarrassing? Sure is. But it goes in one ear, out the other. They don't really give a shit.
Nope.
Doesn't really affect them in any way other than the judge reamed you out. So it's like, I don't think that's appropriate in this case because of everything, because of the history. It's not. And I think for her, it's going to suck because she just invited all this into her courtroom in other cases. She just, and this is also her reputation. And now her reputation as a judge is going to be that this judge is a pushover. This judge will not do anything. Look at what they did in this case. And she just gave them a stern talking to and didn't let them say their witness was neutral or didn't allow their witness. Like that's
been my opinion of her from the get-go, though, that she is a big pushover.
Yeah, but I thought she would at least grow some balls at this point, because now this is pretty egregious. This is pretty bad. So at some point, usually judges grow some balls when it comes to this kind of stuff.
This is going to be the unpopular opinion, but I'm beginning to wonder if the corruption rumors aren't actually fucking true at this point.
On the wrong side, though, the corruption is with them and not the prosecution.
Well, the corruption was with the federal investigation when Levy decided he was going to open up a federal investigation to help the defendant. I mean, that's absurd and unheard of. And clearly somebody was trying to do her some favors, but he's no longer in the office anymore, which is why.
Well, I understand that. And I'm saying to all, you know that there's some truth to all rumors. So what if it was that more times than not, there's truth to rumors. So like, I would hate to think that of this judge. You know what I mean?
I mean, I have definitely seen her, and it's funny because, like, you know, the Free Karen Read people often say, like, she's so harsh on the defense. And it's like, bro, tell me you know nothing about the legal system without telling me you know nothing about the legal system, because she has allowed the defense many motions that she should have never allowed at all and given them a gift, okay? And she has been harsh on the Commonwealth when it comes to basic motions that should have been allowed that were not. So in my opinion, she has given the defense more than the Commonwealth and given them more favor than she has given the Commonwealth.
Guess what I got the other day?
What'd you get?
What?
I got Lego flowers, Elise.
Lego nerd. I happen to like the Lego minifigures. So like one day when I get a P.O. box and I get fan mail, y'all can send me the Lego minifigures. They're like, I collect them. I love them. Oh, I love those.
They're like it was a succulent collection.
I
Hey,
freaking
Legos
love
have
them.
been being put together since Saturday here. I'm so over Legos right now.
I love them. I love Legos.
Oh, mine do too. It's just they're everywhere, and he got some new sets for his birthday, and that's all we've been doing.
I know. Oh yeah, that's right, Brie. I forgot about that. Did have to retire over Rob Kardashian. I foresee an early retirement for Beverly Clinton. You know, it's funny because like she's so worried about appeals. That's her problem. Is she's too worried about what's going to happen if they try to appeal. There is sound legal ground for doing some of these things that she should do. They can appeal until the cows come home, but like they're going to lose. It's just going to get kicked back down. So like a judge should never rule based upon their fear of appeals ever. And I feel like she's been doing that for a while. Like,
Okay,
the federal
investigation.
was the corrupt. Ooh, I like that one. I
Look,
like that one.
It looks like a cactus.
I know, but it's got flowers.
Yeah, I like that one.
Pink. My
Yep.
favorite color. I love it. Well, that's the thing too, Anna. Tainting the jury pool with all the, BS they put out in the media, knowing it's false. And that was Hank's point. Knowing they're misrepresenting and knowing that it's completely false. So Karen the other day outside of court, remember she said, I don't believe the federal investigation is over. Jackson just told you they got a phone call February 26th. They said February 26th. I heard Hank say the 26th. So she already knew because her attorneys knew. So she already knew. But yet here you are saying it's not. Like, she knew it was. They just needed it to continue. They needed the idea of it to continue. They needed it to keep going with their grip. They needed the idea of this federal investigation is still ongoing to continue, and they still need it to continue. They still need the cult to think it's still ongoing. They still need to do that. Like, insane to me. Like, to me, I'm like, what? Come on, Kanoni. Like, come on, dude. You got to step up here. You got to do your judgely duties and put the hammer down, because if you allow people to act this way in your courtroom, it'll just continue on and on and on and on and on with other people. No, it's on some sort of break for the attorneys to talk to each other about something. It's not over. If it was over, we wouldn't still have the fan. It would have ended the live stream. And I heard the judge say something about, I will, Ellen. Just 1 second. My phone's on silent because otherwise all you guys would hear is
Hey,
ding,
Petty.
ding, 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 ding.
Elise, Petty's wondering if she can come up. Petty's one of our friends.
Yeah, it's not an open panel, but if you want us to,
do you want me to
guys wanna
email
send
it to her?
Yep. Yeah.
Okay. Petty, I'll email the link to you, babe.
My beautiful, wonderful mod sent a $20 donation. I appreciate you. I love you. I love your face. If anybody else wants to donate, I'll pop up the link on the bottom because the ticker is like really small and people complain about it. I can't make it any bigger. I wish I could. It won't let me. So while she's doing that, if you want to like, subscribe, hit the notification bell, make sure when you subscribe that you scroll up and like with the bell and go all the way to the top, because it's auto selected for you already and it's not on all. So you actually won't know when I'm live every time if you don't hit the bell and then hit all. So make sure you do that. Share it, of course, because that always helps. And my donations come straight from you guys. That's how I run my channel. So like it says, our small channel runs on donations from my awesome viewers and people like you. I appreciate you guys. I read the good comments out when you guys give a donation. Actually, the other day, because in between the time I was live streamed last time and this time, I did get a $20, I think it was $20 donation from Nina. Nina, I appreciate you. Thank you so much for that. She was on my replay crew. I love my replay crew. And anytime you're on my replay crew and you make a donation, I will always make sure that I read it on the next time I'm live, because it's my way of saying I appreciate you. You know,
So a little backstory on Petty. Petty is from across the pond, and she thought Karen was innocent.
A lot of us did in the beginning. Yeah.
Yeah. And I know that she's changed her thought process given everything that we've talked about and shown and all of that. But I'm going to be interested to hear her take on today. So that's why I was really excited that you let her come.
Well, she's here, so go for it,
Well,
girl.
hey, Petty.
Hi, yeah, you're right.
How are
Sorry,
you,
I took
Petty?
you short live. I'm all right. I'm on the mend. I'm getting there.
Are you feeling better?
Yeah, a little bit. My chest isn't as bad now.
See, Petty, I think I'm sorry, but Kathy and I were talking about you, and we both said the same thing. We wonder if you got a little smoke inhalation.
Yeah, we
I
were both
probably
worried
did.
about you.
I'm okay. It's all good.
I've been really worried. I've been asking everywhere about you.
I know. I have caught a couple of your lives, but I've just stayed in comments. I haven't been feeling up to coming up at present. Unless
I
it's
feel
a dream of
better,
someone.
Betty. I'm really
I'm glad
sorry
you're
all
feeling
of
better.
this is piled on.
No, it's all right. Don't worry. It is what it is. So yeah, today I've been saying all along I thought this were a nothing burger. I don't think Canoni is going to do a damn thing
No,
at all.
doesn't look like it.
Yeah,
No.
it feels that way.
If who's a Libra? No, I'm a Gemini.
Mhm.
But I don't think she'll do anything. I think they both argued really well, and the fact that Yannetti come up and he was apologetic, he didn't come in there all guns blazing, I think showed a lot of respect. I don't think she's going to do anything. And if she does, I think the most will be a fine, if I'm being honest.
I mean, that's the thing. It's like, I think she'll, at the very least, she's got to give them a public sanction, which is like basically when she basically yells at them without yelling, or, you know, in court. She basically tells them what she thinks about it in court. And
Yeah.
that's sort of like a sanction where, you know, the lawyers basically are, quote, in trouble without actually having anything happen to them for them to be in trouble.
Yeah.
Which it's like the least amount of, like, you know, force they can give on something like this, which is why I don't think it's appropriate in this case. But I do think that's where she's headed at this point, and all indications show me that's where she's headed, because if she wasn't, she wouldn't be worried about Little getting something done by Friday. If you were intending on taking these attorneys off, it wouldn't make sense. Hold on, here we go. Hold on.
Okay, so where do we stand? If there was something you all were talking about, is there anything that concerns you?
Not at all, Your Honor. I think the schedule that the court had just articulated is the schedule that we will follow. Mr. Brennan and I have discussed it briefly. The motion to dismiss, Ms. Little's motion, which I can't remember the name of it. The motion for reconsideration, thank you. And the Dalbert Wolf motion, I think we can try to compact all those in together.
So we will.
Done,
Alright,
yes.
so Mr. Leslie, are you arguing the Daubert motion?
I'm arguing the Daubert motion, and I will compact it as Your Honor has just directed.
So let's finish all this tomorrow.
Understood. Thank you.
AKA no long-windedness.
All right, everyone, please.
Yeah, so that her point there to Alessi was no long-windedness. We don't want you talking for thousands of hours. We want to get it all done tomorrow.
Yeah. I think Alessi is really good as well. I think he gets to the point and he argues just the law rather than all the fluff and the circusness that Jackson does.
Alessi talks too much, though. He didn't get to any. He did 4 hours of nothing but nothingness. Like, there was no. He didn't get to the point. The judge asked numerous questions and he didn't answer them.
No,
And
it was just a bunch of fluff and beat around the bush.
yeah, pointing fingers.
Oh, okay. You got opposite
Did
to
you
me
see the
then.
last hearing? Yeah, the last hearing was just 4 hours of him saying really nothing.
Yeah. I did,
So
yeah.
I think the judge's point, like, that's why she asked him if he is the one arguing it, was to say, like, hey, we don't need to hear 4 hours of nonsense. We need you to get to the legal points of your legal argument and compact it, because we have other shit we need to get to.
Yeah.
He does deliberately run out the clock. They did it last time on purpose because they knew that the federal investigation had ended and it was going to be talked about. And so he definitely ran that clock out on purpose.
Yeah. I don't know. This one, I just think it's all been a waste of time, if I'm being honest. I just want this
Yeah.
trial to get going so they can lock her up and she can do her time. Because at the end of the day, John O'Keefe needs his justice. So,
yeah.
well, that's all I had to say. Yeah. I'm going to hop down. I've got my kids to sort for tea times. It's late now for me, so.
Oh, yeah. Time difference. I always forget.
Yeah.
Well, it's good to see you, Pat. It was good to hear you.
Yeah,
I'm glad
it's good to talk to you as well. I've missed you.
I missed
Well,
you too. I'm
I
glad
know
you're
that
feeling better.
I know that a lot of people have been asking about you, Petty. So
Yeah, I'm doing all right. It's okay. It is what it is. All right. I'll catch you soon. And Angie, I'll try and be at the live tomorrow. I love you
oh, you're
both.
fine. Bye,
Bye
guys.
bye.
Thank you for having me up, Elise. Bye.
Oh, you're welcome. You're welcome. Yeah, I
I'm
mean, I
sorry.
agree. I don't.
I missed that last little part. I had to step out with Mason. I got a fear now when he goes outside of losing him because I thought I lost him the other day. So I
Aw.
now, if he goes outside, I stand on the porch now just to make sure that he's not being a naughty dog.
Not
So
going anywhere.
yeah, it was totally my fault. But that's like my new fear now. I just didn't realize. Anyway, sorry. So what happened? They just said they'll come back tomorrow.
Yeah.
Yep.
Basically, it was just, I'll come back tomorrow. And then the judge asked Alessi if he was the one arguing the Dauber thing. He said yes. And she basically said, okay, well, I'm going to need, like, we need to get everything done tomorrow. At like, AKA, we don't need 4 hours of fluff. We need you to, and he was like, I will compact it, Your Honor. Like, yes, you fucking have to. There's other things that need to be done. We can't listen to you for 4 fucking hours. Like, sorry. Like,
No, I thought about something that he said today that he was like, Your Honor, I went in chronological order. And when Your Honor asked me, I said yes. Number one, he didn't say yes. He said, I'll get to that. I'll get to that, Your Honor.
Mm-hmm.
And number two, if he was going in chronological order, he could have gone right down the date and started right off with, on this day, this is what it was, and chose not to waste the court's time. But instead, he just dug himself a great big hole, in my opinion.
Oh yeah, I agree. He definitely dug himself a hole. There is no doubt about it.
It was like filibustering, in my opinion.
Yeah, that's exactly what it is. Like filibustering. Like, first of all, he argued against his own arguments, shot himself in the foot numerous times, basically called ARCA bias, which is what the Commonwealth is arguing for why they should be excluded. And you just gave them that. Like, I don't know where he was going with any of what he was doing because it was not helping him, not in the least bit. And then I see this clip yesterday of Karen's dad going, oh, Alessi is wonderful and he did such a great job. And I'm like, hey, Richie Rich Daddy Moneybags, I'd fire him. He did a terrible job. Terrible. Scrooge McDuck, this is not going well for you. Just saying. Like,
oh, hush. Sir Duke wants to tell everybody his opinion. My cat.
Hi, Doogie.
He's looking for you.
He is, right? For me, it's just like the dude argued against his own argument. And then today, this was the best part for me. He argued again today against his own expert. He argued in this thing that he's arguing against the Commonwealth's expert. He's arguing that an opinion has to have things that go with it, like DNA and blah, blah, blah. And I'm like, you're arguing against your own expert because Marie Russell has none of that. None of it. Then you're arguing they have to have gotten to it based on a scientific basis. Marie Russell didn't have one of those either. So you're literally arguing against your own argument. You don't think the judge picked up on that? That dude is terrible as an attorney for this. He might be great when it comes to environmental law because apparently that's what he specializes in. But when it comes to this, I'd fire him. He would have already been fired. Like, he screwed the defense royally in his last thing. And I did notice, and this is why the judge brought it up this morning, that he kept like saying things, but like not saying it was a fact, right? Saying like, I infer. Like, you infer or you know. And that's why the judge said, well, Mr. Alessi, you said infer, so do you infer or do you know that there are no more communications with ARCA, text messages, emails, any of it? Like, do you know that to be a fact? And instead of him saying, Your Honor, can I take a second with counsel to go ask them, right? to say, hey guys, is there any more communications, like any email, texts? He could have easily, and it happens all the time for them to ask, right? And say, no, Your Honor, I was inferring, but I have now confirmed that to be true. He just said, no, I'm inferring. I do not know that to be true. Like, now the only reason you would do that is if you know for a fact that there probably are other communications and you don't want to perjure yourself by going and asking and then having to lie. It's not rocket science. Like, oh God. Yeah, she is. Yes, agree, Otter. Completely freaking agree with you. 100%. I found it comical that he sat there and argued basically for the Commonwealth's really, really good expert who is absolutely 100% like qualified to be excluded because he claimed that they didn't have X, Y, or Z, even though they did. And all of those things were things that his own expert did not have. Like, you would be lucky if the judge didn't go back and go, you know what? You're right. The Commonwealth's expert does have those things. I don't agree with you on that part, but your expert didn't. So now your expert's out. Like, I say, let the dog lady testify. She sounds like an idiot, and Hank will obliterate her on the stand just like Lally did. It will not go well for them. I really don't like, if I was Karen Reed, I would never allow them to call that dog lady again, because that, in my opinion, would be ineffective counsel. Ineffective counsel. Absolutely 100% would be ineffective counsel for you to call that person knowing it's going to damage you. But she signed that paper saying she can't say that it's ineffective counsel. So sorry, not sorry. Like, sorry, not sorry. Like, I'm hearing there's a meltdown happening over on X with the cult.
Oh,
As
I'm
I
sure.
knew, yeah, as I knew would happen. We all knew that would happen. Like, we knew the cult would have an absolute meltdown. I think that's also why Hank, and I'm going to play that part again, just so everyone can see it who didn't see it, because he makes clear that there is no other investigations into this at all, right? So the
None.
whole point was like, there's no more, like, he wanted to make clear that it's not just this investigation into John O'Keefe's death that is over, but anything that has to do with this case, Karen, the attorneys, the lawyers, I mean, sorry, the attorneys, the cops, the DA's office, like literally anyone. Like, that is why he doubled down to say nothing related to this. Nothing. Like, they would be better to just cross and not put any experts of their own on, because if they also put Lucky on again, like, that's a no-go on them. You're going to tell the world that he would have seen a body, but that he didn't see the basketball hoop and that he can't see 10 feet in front of him face in the courtroom to read something. Yeah, real believable. Sure. And that's why they completely didn't listen to him in the first one, because they were like, he didn't even know what time he was there. He hit a damn basketball hoop. How are you going to, like, come on, stop it. Like, that's utterly ridiculous. So I'm going to go back to when Hank dropped the hammer, especially for people like my friend LG here, who might not have seen that part because she was busy.
I got to go ahead and jump down, but I will definitely be here tomorrow.
Ma'am,
Yeah,
yes,
so I was
ma'am.
just gonna say, I've got a meeting coming up in 20 minutes. So.
All right.
But I will definitely be joining you tomorrow. Thank you, Twisted.
What time
you're
tomorrow?
welcome. I think it's tomorrow is at, so it's not a tentative time because they have to go to the federal courthouse first. So
Right,
it's
it
really
could be.
whenever. Yeah.
Okay.
But they said between like 11 and on.
Right.
If they get there a little earlier, they do. But I would keep an eye out Eastern time for it to be between like 10:30 on a.m. on.
Yeah,
Okay.
I'll be watching for you.
Yes, ma'am.
All right,
I'll
thank
be
you.
here. You're
See you later.
welcome.
Bye.
Bye.
All right, I am going to get this up for you guys because I think it's important to watch it again because Hank does an incredible job. And YouTube is like being kind of a pain. All right, here we go. Let's see. Boop, boop, doop, doop. I have to remember whereabouts it is here. I gotta unmute it. That would help, right? Let me get it up here. Hold on.
Prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people. The history of these violations date back early on in the case, and they continue.
I think it's somewhere around here. Yeah, we're about to do a replay on some of this, on the important stuff.
Certainly, the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on Court TV with Ms. Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is,
Where was that Court TV again?
I can get the date for your honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments, the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me make crystal clear, they made clear that I could inform the court there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over. So all those implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact. And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that. If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance, they can't be. Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact. There should be a gag order on all of these attorneys, every single one of them. And the Commonwealth will not speak either. Ms. Reed, I'm not asking for a gag order for. And so in light of the history of these repeated violations, in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this case, is to impose those sanctions, and that's what I'm asking for. Thank you.
Okay. Mr. Netti, you're arguing this yourself?
Yes, Your Honor, may we approach, please?
Okay.
All right. So, yeah, that's what Hank says about the federal investigation. He asks for the gag order to be on the attorneys, not Karen herself, the attorneys, and sanctions where everything's filed under seal until the court can look at it. I do want to hear the beginning of Hank's argument because it's important too, and I find it funny that he just like immediately goes into letting the world know that these defense attorneys are slimy pieces of human garbage.
Thank you.
That's what I'm afraid of, Bree. That's what I'm afraid of.
As the court's aware, there are certain materials throughout the duration of this case that have been disclosed to the defense pursuant to protective orders. Protective orders are sacred. Protective orders. Protective orders are sacred. If there was no need for protective order, there wouldn't be a need for court intervention to protect the material. When an attorney violates Mass Rule of Criminal Procedure 48, the court can impose sanctions. In this instance, that was the genesis for this motion, there was recently provided materials that the court ordered the defense not to disclose to the public. Those materials, which is some of very important materials. In the reciprocal discovery motion, the defense
They
put
should
the
be.
materials into the public domain
They are.
despite the court's protective order. Now, it's important for the court to determine the nature of that violation because the ability of the court to sanction is broad and wide. There have been other violations, but at this point, a month before trial, and given the history of this case, it is important to make sure that these type of violations don't happen again. What stands out to me in the reciprocal discovery motion that the defense used as a vehicle to disseminate this information to the public
Yep. With
is that they
Velma.
create an argument suggesting why it is important to include this information. In the memorandum, page 9, what they suggest to the court is because the trooper did not want to watch the closing, it implied that he had been following the entire trial.
What the hell?
There's absolutely no reasonable interpretation whatsoever that because a witness, like any other witness who was not bound by a sequestration order at the time of closing, didn't want to watch a closing,
Should have had
there's no good faith basis whatsoever
a
that
sequestration
witness
order.
watch other parts of trial. It is an empty shell to make that suggestion, which then gives them the tunnel to put this information into the public. And when you look at the nature of the information, it's obvious why the defense wants this information of the public. It's part of the consistent public relations campaign they have sought. It is a month before trial, and rather than discuss the facts and litigate the facts in front of the jury, it is a deliberate, ongoing, strategic investment to reach the potential jury pool. And it doesn't matter if it's attacking the trial court, the state police, the prosecutor, the prosecutor's office, witnesses. It is saturating the public with sometimes disinformation, parts of information that inevitably is going to make a juror's job much more harder. It is unfair to the court. It's unfair to the people of the Commonwealth. It's unfair to the Commonwealth. It's unfair to the prospective jurors. And so not only is there really not a logical or a reasonable basis to put this information in, but when we look at the nature of the information, it becomes clear. And so we turned over this information 3 times. We did turn it over as a text message and notice of discovery 51. A protective order was issued, docket 416. We produced it, notice of discovery 57. And again, there was a protective order. And then finally, notice of discovery 58 with a protective order. This is just some of the materials. It is beyond dispute that the defense violated that protective order. So considering sanctions, I ask Your Honor to consider the history of efforts by the defense in this case to disseminate information or to make statements that should not reach a prospective juror before this jury trial starts in less than a month. Now, after they disseminated this information, it wasn't within 24 hours. It was within 24 hours. This was in the local news, the national news, newspapers, online, and it seems that was the very purpose it was spit out into the community. And so the Commonwealth's position is there needs to be a sanction to stop violations of protective orders and violations of the rules of trying to convince the public before trial about a certain side's position. We've had a history in this case that predated me, docket 111, docket 262, where there have been efforts by the Commonwealth to stop, prevent extrajudicial statements. And despite that, it has not happened. There's never been a sanction by the court imposing an obligation for the defense to stop. Rule 3.6 is clear. A lawyer who's participating or has participated in the investigation or litigation of a matter shall not make an extrajudicial statement that the lawyer knows or reasonably should know will be disseminated by means of public communications and will have a substantial likelihood of materiality prejudicing an adjudicative proceeding in that matter. It's important that all parties follow that rule. And there is no retort. The Commonwealth cannot fight fire with fire. I receive inquiries and calls, which I ignore and don't answer all the time because my obligation is a little bit different. It's to ensure a fair trial. Nevertheless, when these type of violations occur, there really is nothing to undo the taint. The history of these violations date back early on in the case, and they continue to this day. Fox 25, the defense is quoted, certainly the Massachusetts State Police is involved. There are people that were in that house that are involved. Brian Albert is involved. Jennifer McCabe is involved. The rest of the folks that were in that house, there's some level of involvement by every one of them. Specifically, 3.6 is particularly concerned about disparaging witnesses, about giving a one-side opinion that may not be based in fact and truth about a witness. It is specifically concerned about the credibility of witnesses. There's been an ongoing promotion to talk about ARCA and federal witnesses and what the opinions are, which aren't in line with reality, the reports, or the testimony. It is a campaign. In addition to this recent protective order violation that got attention that money couldn't buy for a party, other information that was provided in our case, then provided in a collateral case, was again sent out to the public domain. The government has, the defense has not only trampled over 3.6, they've alluded continually about matters that have no basis in fact. January 18, 2024, District Attorney Morrissey is well aware he's a target of a federal investigation. We're aware of today's hearing in Norfolk County Superior Court in the Karen Reed matter. In connection with this matter, at no time has the U.S. Attorney's Office named any person or entity. That was the response by the U.S. Attorney's Office after they implied.
Where was that made? Where was the January 18th comment that you just said? Where was that made?
That was made by Mr. Yannetti, and I have a clip of it. He also appeared on Court TV with Ms. Reed. The Commonwealth is moving for a protective order for these letters after revealing part of what they contain. The Commonwealth wants to keep the remainder of the letters hidden because the letters contain information that will embarrass District Attorney Morrissey and his office. The letters demonstrate that he's a target of a federal investigation for what his office has done to Karen Reed. This is,
Where was that Court TV again?
I can get the date for your honor. Recently, on February 18th, when we were arguing discovery motions, Attorney Little stood up, invoked the boogeyman, a federal investigation, attached themselves to the Birchmore case, and then proceeded to list off a number of troopers' names with no real association or relevance to any discovery motion. And this was a tactic to besmirch these hardworking, dedicated public servants simply by attaching them to a federal investigation for which there is no boundaries. Well, within 24 hours of those arguments,
This is about Aiden.
the Norfolk County District Attorney's Office was contacted by the United States Attorney's Office. And let me
He
make crystal
violated
clear.
the protective order
They
too,
made
in his case.
clear that I could inform the court, there is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters.
Wah.
It is closed. It is
Done.
over. So all those
Done.
implications and innuendos that erode at the objectivity of our potential jury pool, well, they become more egregious when you see that they're not based on reality or fact.
Nope.
And so I submit that the ongoing, deliberate, purposeful poisoning of the potential jury pool is not only wrong and unfair, it needs to be stopped. And
Now.
this last incident of taking a private email under a protective order and putting it in a pleading for the world to see is just yet another example. It's one small step in the marathon. Now, they've made their campaign clear why they're doing it and how they're going to do that.
Yep. They have.
If there's any doubt whatsoever about the intentions of these tactics, I've submitted audio clips to you under seal, and I won't repeat what's in them. But that makes abundantly crystal clear
I'm just letting it play again because it's so good.
why this is happening. And so, inevitably, the court has the ability to sanction. And as an aside, although an accused stands in a different or sits in a different position than the attorneys, grand jury minutes cannot be disseminated either. Not just the paper, in substance,
verbally.
they can't be.
Either.
Doesn't matter who you are. And so the Commonwealth asks the court to consider sanctions so that we can have a fair trial, so that it doesn't limit the parties. It's not retaliatory. We will abide by the same rules. What I suggest is that from now until trial, all pleadings submitted by the defense should be under seal so the court and the Commonwealth can review them and make any objections if there's any material that's private, so that there's no oversights or mistakes or dissemination of protected material. And then if the court and the Commonwealth does not have any objections, then those materials can be provided publicly on the docket. Also, the Commonwealth suggests that the court impose a sanction that the defense must follow Rule 3.6 as the Commonwealth does. No more symposiums on the courthouse stairs. No more interviews with national media. No more statements to press privately behind the scenes over a coffee, putting out information, oftentimes inaccurate, to sell the story before the trial starts so that we can have a trial on fact. There should be a gag order on all of these attorneys, every single one of them.
Boop, boop, boop.
And the Commonwealth will not speak either. Ms. Reed, I'm not asking for a gag order for. And so in light of the history of these repeated violations, in light of the inability for the defense to restrain themselves, in light of their purposeful, intentional, and obvious efforts, in order to best try to maintain a fair jury in this case, is to impose those sanctions. And that's what I'm asking for. Thank you.
I find it funny.
Arguing this, you said?
Yes, Your Honor, may we approach this?
So, hold on. Yannetti doesn't actually address any of that. He goes on to the next motion. And when he goes on to the next motion, he looks like a sad little girl when he argues it. The judge has to remind them numerous times throughout this entirety of today that when you see, yeah, unfortunately, that's part of like monetization is like being a member. So like, I don't have those right now. I did have them. I had to wait 6 months before I could reapply for monetization, and you know, most of you know my daughter is in the middle of the beginning stages of a bone marrow transplant, so I took like a 6-month hiatus for that. So, but I'm gonna reapply for it now. It's gonna usually takes like, I think they have up to 90 days or something to like decide, which it shouldn't be a problem. There shouldn't be an issue with getting it. It just takes a long time for them to do it. So, but when I get that back, those will go back. But it's a pain. It is a pain because people can't send super chats, super stickers. They can't be a member. I can't do any of that right now, unfortunately. And like you said, I only have the 3 options. I don't have Zelle. I tried. It doesn't take my bank. And apparently, by the way, if you guys have Zelle, it says you will no longer be able to like use the Zelle app itself to like send and receive money. It'll have to be through like your bank, I guess. I don't know. That's weird. Never seen like a payment app do that before, but it doesn't have my bank. It doesn't accept my bank. So there's that, I guess, which is so weird because it's like if Cash App and Venmo and PayPal accept it, it's just weird that Zelle doesn't, but whatever. Yeah, the red tape is the song and dance is ridiculous. You know what I mean? But again, it's what happens when you get harassed by a cult since 2023. So I guess it should be, you know, I just take it with a grain of salt, take it and I move on, you know, like every single day it's something with these people, whether I get a text or an email or a DM, some new threat, some new insult. And it's funny because it's like, if you're going to insult someone, at least try to be factual or actually make sure it makes sense. You can't insult someone with something that never happened or insult someone with something that like isn't true. There's like, where's the insult if it never happened? Like, you know what I'm saying? Like, so it's like most of them I literally just like point and laugh at and literally die laughing at. Like, I will literally be on the phone with somebody dying laughing reading them. Like, you took the time out of your day to text, call, email, whatever, a stranger you've never met a day in your life and anything like you know nothing about, right? You took the time out of your day to do that, to either threaten them, disparage them, insult them. Like, what's wrong with you? It speaks more about you than it does the person you're trying to like insult or upset. And it's like, bro, I've been dealing with this since 2023. Like, it doesn't upset me. I laugh at you. Like, it's sad. And some people I do feel really bad for because I feel like they're stuck in this cult and they don't realize it until they're no longer in it. Like the damage it does to other people and like the harm it has caused to other people and that they're hurting themselves. Like, they're only hurting themselves. Like, it's sad. It's really sad. Like, they've affected people's, you know, a way that like Chris Albert, they've gone to his pizza shop. It's loss of income, dude. Like, they've affected numerous people's income, calling their jobs, doing this, doing that. Like, there's been a loss of income for many people. And there are things that happen when you lose income. You can no longer pay bills, or you can only pay parts of bills, or maybe now you don't have enough food in your house. Maybe you have to pay part of a gas bill, part of an electric bill, or you know, if you have a car note, or maybe you have to travel to buy cheaper gas, if that's even worth it, depending on where you're traveling. If you have a car, I don't have a car, I don't have a car note, but like if I did, those would be things, you know what I mean? Like any of those things, like it's like a domino effect. And so many people have had to deal with it for no real reason other than people not agreeing with their opinion and a sewer turtle who spreads false rumors, lies, bits of information, misinformation, crops things, puts them together to try to make it look nefarious when it's actually not. Like, the list goes on and on, literally. Like, so it's like cyber stalking is a real thing. But again, I digress to my shirt that says I'm going to let karma handle it, because if I do, I would go to jail. I will digress to my shirt and let karma handle these people, because whether it's insta karma and it happens right away, or it's karma that happens down the line, if you put shitty karma and bad karma into the world, that is exactly what you will get back. I choose to put good karma in my karma bank and put good karma into the world. I don't choose to put shitty karma into the world because I don't want it back. I don't want it back. I worked in the prison system. I worked in a prison for the criminally insane. I am been 18 years sober from opiates. I was once a very low bar criminal. When I was very, very young, I was a very broken, traumatized girl who had been through a lot of trauma. I have CPTSD for the rest of my life because of that. I've been in therapy for 20 years because of my abusers. Okay. All the things that I have been through have made me a better person along the way. So they can, be like, oh, you're a junkie. Well, you can't be a junkie if you've been sober 18 years. I drink maybe like 10 times a year, vacation, birthday, Christmas, maybe a wedding, something like that. Sometimes less, sometimes like 4 times a year, like a year, not a month, a year. So for me, a lot of this stuff's just laughable because it's like you can call someone a junkie, you can call them fat, you can call them ugly, you can do all those things, but if none of those things are true, we just laugh at you. It's like, what do you think you're getting out of it besides, attention? You know what I'm saying? Like it speaks more about you than it does the people you're trying to disparage on a daily basis. If you're taking your time on Facebook or Twitter or any other place to go stalk someone and make disparaging comments to them, then you have no life. The fact that you have the time to go do that is just sad. Find a hobby. Find something else to do. Like, you guys are my hobby, right? Like, I love coming here because you guys are awesome, always. And I love the law. I have a passion for the law, and had it not been for the medical stuff with my kid, I would have already finished school, passed the bar, been there, done that, right? Like, so they can say really whatever they want about me, but the people who know me well know what kind of person I am. They know who I am. They know I would help anyone, no matter who you are. If you came to me for help, I will help you. Like, that's who I have always been. I have never turned someone away and said, no, I won't help you. Ever. Not once, not ever. So, like, they can say whatever they want. I know the truth. The people who care about me and who talk to me on a daily basis and see me know the truth. So it's like, at this point, it's like you're wasting your time throwing rumors and lies out about people you don't know. And this doesn't just include me. We're talking everyone they do it to, Lindsay, the witnesses, the family, like any other person who has a public, show or stream or platform of any kind, like Tuesday Gazette or Julie Carpenter or any of these other people that they just love to harass, Lindsay, like any of these people that they love to just harass. It's just insane to me. Like, you took the time out of your day to go talk shit about someone with false information that a cult leader gave you or one of his minions gave you, out of context, misrepresented, put together nonsense, or just flat out completely false because he gave you a dog whistle to? I'm sorry, what? In my opinion, it's like, okay, that's your loss. Like, some of these people are kind, amazing, beautiful people. And so if you want to harass and disparage and try to insult these people, then it's your loss because you don't have those people in your life and didn't try to get to know them in any way, shape, or form. Like, that's on you, not them. It speaks volumes about you. Okay? You, not anyone else. You. Like, that's really sad. Like, good for you. Good for you, Wolf. More people should be proud of that. That's what pisses me off is, or, it even bothers me when people say to Sean, like, oh, have another drink, Sean. Sean's a recovering alcoholic. Like, you don't have to like Sean. But that is so low to sit there and say, oh, he must be drinking because you don't agree with him. Like, come on, man. Come on. I have been sober from opiates closer to 20 years, okay? Or 18 years. That's a long time, all right? But I don't give a shit if it was 18 minutes. Anyone. And I had to pass two background checks to work at the prison, one for the DOC and one for the private company that took over the prison. 2 to work at that prison, all right? So it's funny to me when they're just like, you're just a this or just a that. Like, you know nothing about me. Absolutely not a single thing. The same thing about everyone else that they disparage. Oh, the reason why he hates me, most people know why the reason why he hates me. Because I found out about his numerous escapades while he was married. And one of the girls he was seeing called me bawling her eyes out because had just admitted he was bringing another girl to a party that she was supposed to be going to. It was really low what he did. But then if you fast forward till after he attacked me because I knew this information and because I also knew he was like lying to the public, and also because he was hating that people were telling him they liked my show. So like that would make him like rage out apparently. So instead, he decided that he was going to attack me with some ridiculous nonsense and claim some ridiculous nonsense that wasn't like a thing, because he was upset that I knew this information and I could possibly tell the world. Also, just for the record, never was going to bring that to the public because it like didn't matter to me. But like now I have to tell the story because he's a whine baby. But that's ultimately the reason why he started attacking me, was because I found out about that. And then a third woman found me. And now she happens to be a very, very good friend of mine, but a third woman that I didn't even know existed found me on my stream through someone else and just popped in on my stream one night. And 3 women besides his wife at that point. So yeah, I think it should be studied, Otter. Honestly, it should be studied. It is a phenomenon. I think it should be studied, like how easily misled people can be, why they continue to believe things when it's literally in front of their face, and they'll just be like, no, the sky's not blue, it's purple, because the sewer turtle told me it's purple, so it's purple. You can say it's blue, but everyone's lying. It's not blue, it's purple. Like, do you know how delulu that sounds? Like, how absolutely delusional? Like, absolutely delusional it sounds. Like, come on, man. Like, oh yeah, flat earthers. Those ones are, I'm telling you, some of these people have to be flat earthers. I can't. It has to be that way. There's no other explanation. It would be a great thesis subject, because we think of cults as like, Jonestown or Heaven's Gate, as someone pointed out the other day, like those, like, or Waco. Like, so like, you think of it in that aspect, but people don't seem to realize cults don't just have to be that, right? Like, if there is one person that is preaching, and it doesn't have to be religion, it's an idea to a lot of people, right? And these people will believe it no matter what. And if you question that person in any way, shape, or form, they attack and they attack and they attack, and you're not allowed, and you put other people in fear of questioning, because if they question, they could be next, so that they don't question. That is a cult, and that is a cult leader. And he's not the only one that we have online. There are quite a few. But this phenomena itself, like Dahlia Vu, okay, that means madness for two. All right. And it's shared delusion syndrome. There's also one that goes into shared by the many instead of just two. So what it is one person who is telling these delusions that might seem like they could be true to another person or other people, and then those people then adopt that delusion as a truth. That is exactly what we've seen here, except it's not just one person, it's the many, right? There's actually like a medical diagnosis for it, okay, called shared delusion syndrome. And then it's called something else when it's more than one person, when it's many. But I mean, when the cult leader itself knows that the things that they're saying are not true, but they keep doing it, I don't understand how people don't pick up on it. Like, when you contradict yourself in the next sentence, or the story you told 17 times changes every single time with little details because you can't remember what lie you told. So now you just got to tell it again, hoping that the lie that you told last time is the one you're going to tell this time because you can't remember which lie you told to who. That's a problem, right? Like, and ultimately all of that is what's going to sink that battleship when it comes to court and a trial. All of those statements, all of the things that he admitted to and then didn't admit to, don't jive, okay? They just don't. Yeah. He said that? He said that, or someone else said that? And she's finally off the couch. Oh, yeah, sorry. I did. Sorry. I didn't see you in chat, so I didn't want to read it until you got back. I thought maybe you were like, at work. I did. I got the super chat, non-super chat, because I don't have super chat here. So as we know, if you want to donate, you have to do Venmo, Cash App, or PayPal. But I did. Bree sent me a very wonderful $25 dono. I appreciate you, Bree. And it says, here's my super chat. What are the writers going to do with AJ admitting there are no new videos? Just new copies of the ones they already have. Interesting. Yeah, you could actually, yes, Ellen, that would actually be really helpful. I appreciate that. I'm reading your text. So yes, that would actually be helpful. I appreciate you. That's an interesting question, darling. I don't know. I'm guessing they come up with another conspiracy. Yep, folly ado. Yes, exactly. Thank you. That's exactly how it's about. Folly ado. It means madness for two. And that, yes, mass hysteria. Thank you. That is the one that is with numerous people. And it's actually in the medical books, of course. That's like sad, like, well, that's another thing. I mean, again, I will put the disclosure that anybody who is a content creator is, oh yeah, you're right, I will play it, is going to try to make money. It's common sense, right? Like, you're taking your time out. Hopefully you've done some research and some work behind your show, and you're not just pressing the button and going. I am told some people do that. I don't know how they do that. I would feel like an idiot if I did that. And did no work whatsoever. You don't talk to sources. Like, some people don't talk to sources. You don't make sure your information is correct. You don't, like, no, nothing. Like, nada, you just press a button and go. Cool, got it. But you would hope that some people are doing some work behind the scenes. There are costs involved with being a content creator. You got to pay for certain things like this, where I stream from at StreamYard. You have to pay for that. That's almost $50 a month. It's like $44.99 a month, and then on top of it, you do your intros and your outros, and you have to hold the license for that. So whether you do it on Canva or somewhere else, you have to pay to have that monthly. So that's like, $15 to $25 or more, depending on which thing you use. So, and then there's other costs, lighting, all that stuff. So like, all the stuff that you need to stream. So it's like, if you're trying to cover the cost first, then you don't actually make anything if you're just covering the cost, right? So I will say that, like, content creators in general should, of course, be making money with their donations. Like, hopefully that's what you're doing. Smaller content creators, like, they don't really make much, like, you're not going to make much. Like, I'm a small content creator. I'm not going to make hundreds of dollars a stream. Like, maybe eventually, but I don't. I barely hit 40 or 60 a stream, but that's all right, because I'm a small streamer. It is what it is. And to me, it's more important that the truth come out, the truth, especially in this case. It's hurt so many people, like, that it is here, like, but yes, I mean, everybody as a streamer should be making some sort of money. But when that money overtakes you willing to tell the truth, and you're willing to lie to get more of it, that's when it becomes a problem. That is when it becomes you doing something shitty. Because if you're just willing to say what's popular for the dollar sign, then nobody can trust anything you say. You're not credible. Nothing you say is credible, because you're just going to say whatever the popular opinion is, right? Like, I refused and still refuse to do that. I won't do that. Like, I refuse, absolutely refuse. And that's another thing. Like, people, I used to love when they'd be like, they still do it, like, oh, you're a grifter. I'm a grifter. Dude, I took a 6-month break. Like, in order to be a grifter, you have to actually grift something, right? Like, if I'm streaming, any streamer should make money. That's kind of the name of the game, right? But when you're willing to lie for it, that's when you become a grifter. I'm not willing to lie for it. Sorry, not sorry. It's not a thing. Like, you want to, smash your integrity into the wall, you be my guest. But I choose not to do that. And if I was boosting exposure, because like you said, like, a lot of them do it, then I would be posting on Twitter. Like, every time I post on Twitter more than once in a day, my engagements fly through the roof. I don't, because when I want to say something, I I want people to listen. So if I'm tweeting something, you can damn well know that if I'm tweeting it, A, it's true, and B, I'm saying it for a reason. So I don't need to just endlessly tweet 17 times a day just for exposure. Yeah, that would make my engagements and my numbers go up. It would actually make me be able to monetize my Twitter. I could have already done that 10 times over. I choose not to, because I don't want to just be endlessly tweeting about things that we've already talked about or that have been said 17 times. Like, I'm going to tweet about what I think is important, or I'm going to tweet about dispelling some sort of lie, because I'll get screenshots of random shit, and then, you know, once in a while I will respond to it on my own Twitter. But I only have one Twitter. I answer from my Twitter because I want people to know it's me and it's coming from me. I don't need a fake Twitter. I have my own Twitter. Like, I don't need to do that. I have people who send me screenshots every day, all day, about different things. Some of it so ridiculous, and I'm like, wow, people like say the craziest shit, dude. Like, but come on, man. Like, oh yeah. I mean, I've had them for prescriptions after surgeries and not even finished the amount. Like, again, it's been, I mean, I've had them twice for teeth teeth work over the years. Over the last 18 years, I've had it twice for teeth work and once for a separate medical surgery. But that's it. I have never outright refused them. I take them, but most of the time I don't even take the whole full prescription, and they usually only give you like 10 or something. I actually use it for what it's meant for, pain. My problem was never the opiate pills, unfortunately, but again, that was a whole nother lifetime ago in my life. You know what I mean? Like, when you figure out the reason you were using to begin with, then it's easy to nip it in the butt, you know? Like, and a lot of it has to do with trauma, a lot of trauma that people deal with, and you just don't tell anybody. You hold it in for a really, really long time. And years, some people hold it on till the day they die. To the day. My father, who was my stepdad, who adopted me when I was 4, is my dad. To me, that's dad. That's what I got this tattoo for that says daddy. And it's, you know, angel wings and a cross. But my dad committed suicide when I was 21 years old. And he didn't tell anybody the pain he was feeling inside from the abuse he suffered as a child. We had no idea. I had no idea. My mom knew, I didn't. Obviously, none of his kids knew. But I like to think that if he had told someone, that he'd be in a better place and we'd have him here today. You know, like, I think mental health is really important. And I think it's underscored a lot of the time by people putting this stigma on getting therapy is a bad thing, or you must be crazy. No, therapy is a good thing. I still go to therapy because I have CPTSD, and it doesn't go away. PTSD or CPTSD doesn't magically go away. It doesn't disappear. I also have myocarditis of the heart and fibromyalgia. I was born with liver issues, so I have those. Like, I have a multitude of health problems. Thank you, COVID. I appreciate it. Most of them came from COVID, aside from the, obviously, CPTSD and the liver issue, because I was born with that. I was in the hospital for months when I was born because of that. Like, but, you know, did you say acupuncture? Oh, I'm like, I've tried acupuncture. It does not work. Yes, exactly. That's a good one. Oh, hey, girl. Hey. Hey, Ashley. Well, yeah, most people know that. But I mean, once again, when they say it, I literally burst out laughing at this point. I'm like, you have to actually, like, you have to grip something and, like, what? That's the thing. There'd have to be a lucrative side to it, right? Like, this isn't lucrative, to tell the truth. People don't want to hear it right now. Like, they just want to stay in the bubble of the echo chamber of she has to be innocent, because if she's not innocent, then we've been doing this since 2023 or 2024 for no reason whatsoever. And dear God, the things that we have said or done to actually innocent people, or people who didn't do anything wrong, or people we hated for no reason, they don't want to think about that. They have to double, triple, and quadruple down, because if they don't, right, then that's the realization they're going to have to come to, is that maybe they were being a shitty person, and maybe they got roped into it, and maybe they were lied to, and how the hell didn't they see it? And it makes them feel like they look stupid. You do look stupid. But I promise you, realizing it and going to people and being like, oh my God, I feel so awful. I feel terrible. Like that, like people aren't going to reject you for realizing what happened and that you were duped. As a matter of fact, more people than not, especially over here, like are very kind about it, where they're like, listen, at one point we believe she was innocent too. You're not the only one. Like, we're sorry you're just seeing it now, and we're sorry you're just realizing it now, but you're not alone. Like, nobody is going to sit there and like, you know, call your phone and text you because you realized you were lied to. Like, it's not a hard thing to be like, wow, shit, I would step outside the echo chamber for a second, step outside that box and take a look at all of the things you've been told and all of the things that ended up being a lie and realize it's not true, right? Like, she isn't innocent. I love when people go, well, where's the evidence? Yeah. You mean the taillight in his clothing? The taillight they found under the snow that couldn't possibly have been put there because it, A, was under the snow, okay? And B, the 13 was already there, all right? In which they video recorded that. So, yeah. Also, when Karen's car backs up, John's phone stops moving forever within seconds and never moves again until they find him, and it is underneath him. That is just as good as if you videotaped it happening, okay? She was right there when he stopped moving forever. Okay? Like, it's ridiculous to me. So that when they say to me, where's the evidence? I'm like, I refuse to answer that question again. I refuse to answer it again. And I'll tell you why, because I've answered it so many times at this point, and they just either crickets, they disappear, or they'll say, well, all of it's corrupt and you can't believe any of it. So it's like, no matter what piece of evidence you brought some of these people, until the end of time, they would just say, this guy's not blue, it's purple. Sewer Turtle told me it's purple, it's purple. Like, okay, you know what? You want to continue living in Delulu land, that is on you. Like, that is on you. Like, I can't. Like, ridiculous. Now, I have arthritis too. It is painful. Psoriasis as well. Not fun. I have it on my face. It's like in my cheeks. It gets pink right here, and on my leg. Yeah, you guys would have loved my dad. My dad was a funny guy. He was a musician. He played instruments. He taught kids instruments when he worked at a instrument place that taught lessons. And he was funny. He was so funny. My dad was a jokester. That's for sure. I don't know about heroes. You know, I don't like to say the word victim. I like to say the word survivor. I'm not a victim, I'm a survivor. You know, I'm a survivor of domestic violence. I'm a survivor of addiction. I'm a survivor of abuse. I'm not a victim. I'm a survivor, right? It's sad. It's really just sad at this point. Like, yep, I have fibro too. It sucks. It sucks. You're not the only one, that's for sure. So if you ever want to talk and just get it off your chest and be like, today I hurt and I don't want to move, Elise, I'm here, dude. Believe me, I get those days too. There is a sort of sign of intelligence to admit you were being lied to and you got duped. I got duped, and I'm a very intelligent person, as are a lot of you, right? Like, when there was no evidence to look at, yeah, it was a plausible thing, but there also wasn't all these extra details that they have added and subtracted at this point. But if you realizing it is to be like, oh shit, I was duped, right? Like, but to double and triple down, even when you know deep inside something ain't right, like, that's where they get me, you know? Like, yeah, he did, actually, exactly. And Ashley proved it to be completely false, okay? And in that case, he, as he always does, manufactured evidence, tried to set people up. And I find it funny that he says, like, everything is a conspiracy against him and people set him up. Because I kid you not, when I say for years, that's literally what he's been doing to other people to get his revenge for them telling the truth, is setting people up. Like, faking shit to make it look like it was them. Like, I kid you not. Like, so I find it so tone deaf for him to claim some sort of giant, vast conspiracy setup. Nobody set him up. Everything he's done to himself. Like, he did it to himself. Nobody told him to go to his ex-girlfriend's house and threaten her and her children and, wiretap. No, nobody told him to do that. He did that all by his lonesome. It's not, he didn't get locked up because of journalism. He didn't get locked up because of Karen Reed. He got locked up because he committed a crimes, multiple crimes. That's why. Nothing to do with the First Amendment or Karen Reed. He got locked up for the shit he did. I bet even Karen Reed's tired of him saying that because it has nothing to do with her. Literally. It is vile. It is vile. It is very vile. And that's the thing. It's literal just gossip. He'll literally he will publish anything someone tells him. If they say, I know for a fact, he will publish it as truth when it is not. And then even other people who have had things published on them, who have literally given him proof that the thing that they were saying is not true, like, hold on a second, guys, I'm getting a call. Sorry, guys. My kiddo has like a event at school coming up, and they were just calling to make sure we're still attending because they do like a count to make sure they have, enough drinks and pizza or whatever. We sent the little thingy in. Yeah, it is Delulu. It's absolutely Delulu. You know what? It will be. I believe that karma does its job, and in one way or another, it will be. It doesn't always have to be everyone's idea of justice, but I fully believe that justice will be served in whatever way the universe thinks is appropriate in this case, you know? Yeah, it's rough, that's for sure. It does. A lot of this stuff does make, not that you should have to go through it for it to be making you stronger, because you shouldn't, right? None of us should have to go through this crap to make you stronger, but it makes you a better person. It makes you more empathetic. It makes you more sincere. It makes you understand better the things other people go through and why, and how you can't just jump to conclusions on things, because there are answers for things. There are actual real life, like for instance, when people go, well, why didn't Brian Albert's dog Chloe wake up? My daughter has a service animal. She has 3 actually, but one's a German Shepherd, okay? And I will tell you that that service animal does not always bark. As a matter of fact, at night when he's sleeping, he does not bark. He does not bark at things outside because there's a street and stuff right outside the window. Feet, cars going by, beeping, whatever. Like, he doesn't just start barking. Like, unless you're pounding at the door, he doesn't just start barking. Like, that's not how that works for every dog. Every dog is different. So for me, it's like, why didn't the dog bark? Because it didn't. Like, what do you mean? It just didn't. They don't want to talk about John, because if they have to talk about John, they have to realize that he's the one being forgot in all this, and his memory is the one being forgot in all of this, like it, and it's not fair. It's not right. It's just not. Like, John was a good person, and his family are good people. Okay? The Alberts are good people. I've never met the McCabe, so I can't speak on that, but I know a couple of the Alberts. I have met them, and they're wonderful people. Wonderful people. And it's like, the shit they have been through is inexcusable. Inexcusable. John's family, his brother, his mother, his father. Peggy's a rock star, and Paul is the rock in that family for Peggy. Okay? And he's an amazing person, and Peggy's an amazing person. So it's real shitty when people don't see anything wrong with them being harassed or gone after. Leave the family alone. You don't have to be real low to think that that's okay. You know, like, it's crazy. Oh yeah, yep, that too. That's the only thing he denies. He admits to pretty much almost the entire thing, except for the push on the couch, which happened, by the way. Please hold for commercial, right? I know, I'm sorry, I had to take that phone call. Hey, girl. Hey. Yeah, well, I think, karma will come in on that end and take care of that. You know what I'm saying? Yeah. Let's hope so. I know that I know that like his trial isn't probably going to be until after Karen, so it's like it can't come soon enough in my opinion. Like, we miss Heels. We miss her so much. We started streaming the trial last year with her, and I know she's watching from up there now. It's real shitty because the accident where she passed away happened while we were actually live streaming with her. Obviously, there was no video on her end because she always kept her video off, but it happened while I was streaming with her, so that was a really hard one for me. But I almost didn't stream the rest of the trial, and then I said, she really wanted to stream this trial. So I am going to put my big girl pants on, and I am going to stream the rest of this goddamn trial because that's what she would want. She really wanted to see this come to an end. And I know she's up there watching it. I know she is. I can hear her commentary in my head. And she was a good person, a kind person. So we always keep her memory alive here, you know? Yeah, lots of compassion when you go through a bunch of shit. They are very intelligent. Very intelligent. Very. Oh, I bet. I freaking bet. You never once hear Karen say that she loved John. And that speaks volumes to me. Not once. In all those interviews and all those things she's done, not one freaking time, not one, did she say, I loved that man. I loved John. Not freaking one. It's just awful. Like, the hell? But besides saying he was the patron saint of Canton, and I really believe that was more about what other people thought of him, because that's what was being spoken about, than what she did, you know? See, that's the thing. So many people, we're in the hundreds because of one person that couldn't take responsibility for their actions. One woman, one privileged, white, rich woman. Chris is an amazing person. Okay. Chris is a very kind person. I adore Chris Albert and his family. And yeah, it has affected his business, and he helps the community. So if you do ever get a chance to go down to D&E and you're in the area of Canton, I would tell you to please go down there and show your support by helping the business out. Go buy a pizza. Their food's actually really good. And their chicken palm is anything but mediocre. So I would go down there if you guys are in the area, and that's like one small way to like just show your support is like, go buy a thing of fries, buy a drink, pop in and say hi. Like, we just wanted to say, like, he's there a lot, like, you know, and he'll talk to you, he'll say hi, and he's very courteous and he's very kind. And I think that's a great way to show your support if you're in the area, you live in the area, or you're going past that area, to hop in to D&E and order some food, you know? It is still open, yep. It is, right? It really is nice to see decent people with common sense. It really, really is. Really. I do, Lotsy. Yeah, see, that was a tough one for me, that live. It was tough. Oh, I have no doubt that she'll be found guilty this time. Hank has pretty much destroyed any argument that they have, and I don't think any jury is going to, a non-tainted jury, is going to find her not guilty. Seriously. Seriously. It's not that far. It depends on what part of Rhode Island you're in, but, you know, if you're anywhere from, like, the middle of Rhode Island, it's about an hour. If you're closer to, like, the border of like Pawtucket and Central Falls and Attleboro. It's probably like 35 minutes if you drive through. If you want to take like the highway, it's probably like 40 minutes. But like, if you're going that way anyway, if you go that way anyway for any reason, I would say stop in. Well, that's the thing. They've done nothing wrong, and yet they've had to deal with all this. Like, that's crazy to me. I did find all of y'all. And a lot of you did. You came from Hills over here. And I love you for that, because I feel like her viewers deserve someone who's going to speak the truth, or someone that they at least get to enjoy to watch too, because they did lose her so suddenly. Like, yeah, it is. Yep. Yeah, and I mean, that's the thing, is Chris doesn't ever, he didn't stop giving, good free community food just because he was struggling either. And I think that speaks volumes of who he is as a person, because he still believes in doing things like that. And it's everybody should take note and be more like that. Yep. That's such a great idea, Ashley. That's a good, listen, if you go, I'll go with you. I'll go with you. You just let me know. You write me an email. I'll go with you. If you get, we could do it in a group. We could have a little outing. You guys let me know. Send me an email. twistedtragedies3@gmail.com. I'll totally go with you guys. We can have make a little outing. Yeah, I know. Non-tainted, but that's gonna be it's gonna be hard. Like, that's gonna be hard to find a non-tainted jury, which is why I think that they should have done a sequester last trial, and why they should do a sequester this trial. I don't think they will, but I think they should have. That's the problem, right? In Mars or Tokyo, that's where you'll find them. It's sad. No, the court's done. I was playing Hank's part over again because I thought it was important to show about the federal investigation. So I played it again because some people missed it, and it was worth watching again. That's for sure. But you're right. It's going to be hard trying to find, jurors that haven't heard about this. It is going to be hard. It's not going to be an easy task, but I do have faith that Hank will get it done. Absolutely. Like, I do believe that. I know. I say that too. Like, they need to check the social media, because as we know from the last trial, there was very clearly at least one, if not numerous, Karen Read people who were on that jury who absolutely 100% knew about this trial before they became a juror. Like, it's crazy to me. Absolutely freaking crazy. I just don't understand it. To me, it just doesn't, like, sequester the goddamn jury. Make sure they're not looking at any social media when they go home, because it's like clearly one of those jurors, at least one. I think there was a few. There was, quite a few. Listen, we almost ran out of jurors, alternates. Okay. So also, I think this time they'll need more than what they got last time. I think that they'll get a few extra just because so many were dismissed last time of the alternates. But I don't know. I think they should be sequestered. Absolutely, 100% should be sequestered, because how do you keep them from doing the shit that they were clearly doing in the last one? And clearly at least one, if not more, in my opinion, there was more than just the one, knew about it ahead of time, lied to the court, put their hand up every day and lied to the court, committed perjury. That's perjury. Okay, perjury. You're lying. And said, no, Your Honor, I've never heard of this case, and I didn't see anything online, and blah, 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 whatever. Okay? That is not okay. They did all that so that they could be the one holdout. Like, okay, well, you could be a holdout, but again, that's an acquittal, right? Like, that's a hung jury. So, like, the hung jury means another trial. Like, you got it. You don't get, like, you got to go again. You got to do it again. So it's like, you could be the one holdout, but they're going to do it again. So it's like, unless the whole jury is pre-carried, you're not getting a not guilty. That's the problem. Like that they don't seem to grasp. They think if they're just the one free Karen Reed person on the jury, that it's like gonna happen for her. Like, make no mistake, if there was another hung jury this time, Hank will try it again. Make no mistake about that. He will try it again and again and again until there's an answer. Like, but there's too much evidence at this point, and her own statements are going to sink her like a battleship. Like, literally. You know, she's made too many inconsistent statements and changed her story. Steve, we know who did it. We don't know who did it, Ted. And it's not for us to know. But Steve, everyone knows who did it. We know who did it. Alan Jackson saying that, you know, everyone in the house had something to do with it. Aiden changing his story about it. Was it Proctor that sprinkled the taillight after he said for a year that Proctor sprinkled the taillight? It was him. It was Proctor. He's the one who did it. Now it's he didn't do it. It was the guy who was in the Sally Port with him. Like, the fact that these people over there don't go, wait a second, you've been telling us for a year that it was Proctor that sprinkled the taillight. Now it's not him and it's someone else. Like, you don't stop and go, what? He's getting his information straight from the defendant. The truth doesn't change. Okay? It does not change. It stays the same. So if she went from we know who did it, everyone in the house had something to do with it, to we don't know who did it and it's not for us to know, that's a freaking problem. That's a freaking problem. Thank you, Ren. Like, come on now. That's cuckoo bananas. We're talking like time to wake up and smell the roses and realize you were lied to. It's not, you know, hard. Like, listen, I think it takes guts to admit when you're wrong and apologize. All right. Yep. Yeah, exactly. They did, and we did this at trial when you guys watched me. It was a pick one anyone. And I told you guys during trial, juries don't, at least here in Mass, juries don't like the pick one anyone style. That might work in California, but that does not work here. If you're going to say someone beside your client did it, no, you're not required by law to prove it wasn't. But if you're asking a jury to have reasonable doubt, then they need to actually have some reasonable doubt of who it was, not just it could have been this person, this person, this person, and there's too many that you're saying it could have been, right? Or implying that it could have been. They would like to know who you think did it. And at trial, it was a pick one anyone. They were just inferring that everyone did. Like, everyone. Like, all the people. Like, Colin. Now, poor Colin, you ruined a kid's life. How do you all feel about that? You ruined a kid's life. And even Karen herself says after the first trial that there was no bad blood between Colin and John. Nothing had to do with it. There was no drugs from Colin. Like, all of these things were false, not true. And she waited till a dinner she had with her other, you know, all of her PR. And you guys forget, I was one of those people at one point. I know how she controls. And I kid you not when I say down to the very first time that she attempted to have control over my channel, I immediately blocked the person sending the message from her. Okay? If you care about Karen, you'll stop talking about that DNA right now. She doesn't want that talked about. Insta-block. Then they went to my Twisted Tragedies Facebook page and sent me a message there because I had blocked him from my regular page. Well, you don't have any sources and you're pathetic and blah, blah, blah. Insta-block the second time. If I didn't have any sources, then I wouldn't be talking about non-public information about DNA that no one else has talked about. If I didn't have any sources, I would not have known about the immunity that Natalie had that, if you remember correctly, the sewer turtle told everybody was untrue. I had no idea what I was talking about. Why would Natalie have immunity? That was also not to be lied to you again. So we're talking a channel with, at that point, because, you know, I lost a lot of the free Karen Reed people, which is totally fine with me and a bunch of people anyway. But around that time, it was like a little over 3,000 subs. So you're talking a very small YouTube channel that she is trying to control. So if she was trying to control my small channel, do you really think she's not controlling bigger channels? What they say, how they say it, what she wants talked about, what she doesn't want talked about, what she wants pushed, what she doesn't want pushed. I know for a fact that's how it works. And the first time that was ever tried with me, I immediately shut it down because no one, and I mean nobody, tells me what I can say or what I can talk about on my channel. I talk about what I want to talk about. I'll say what I want to say. The information I get from my sources is the information I get from my sources. You're not giving it to me. I'm doing my own legwork for information. So you can F off. No one on planet Earth is going to tell me what I can or cannot talk about on my own channel. Definitely not a murder defendant. And that was another red flag for me at that point, was like, why would a murder defendant need to be controlling what YouTubers say on their channels? I have never seen that before, and that was a huge red flag for me. Huge. Once again, things that people ignore for 700, Alex. Like, I know, really though, 150 nights at the Omni. Also, I think everybody should let Smith and Walensky know that it's absolutely disgusting if they're comping those meals for a murder defendant. I think that's absurd and gross, and I don't know why a place like Smith and Walensky would be comping a murder defendant's meals. That's fucking disgusting. Like, I would never eat at your establishment. And I heard she's eating at Davio's. I love Davio's. I've been to a Davio's a million times. Please don't go to Davio's anymore. I don't like you. You're ruining the places that I like to go to. And I've been to Davio's a billion times. They have delicious food. But I know Davio's most certainly is not comping her meals. So why is Smith and Walensky? Like, why? I don't understand it. It makes no sense to me. All right, so let's break this down quickly. They're going to argue the motion to dismiss tomorrow. What I expect? The same crap from Alan Jackson. Blah, blah, blah. The Commonwealth didn't give us videos, and they gave us videos late. Egregious conduct for us to get them late. Blah, blah, blah. Jury tampering, because Fanning never went into the courtroom and never actually spoke to any jurors, but it's jury tampering. Blah, 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 Your Honor. Hank's going to get up and say, Your Honor, Lieutenant Fanning never entered the court nor spoke with any jurors. Therefore, there cannot be any jury tampering. Your Honor, we gave them videos when we knew they existed. They now have them. There is nothing exculpatory in them. We don't even have to give them, but we did in good faith anyway. And it's the same stuff they already have. Okay. And then the judge goes, I'll take it under advisement. Then a couple days or a week later, you will get the denial of the motion to dismiss, because I have no doubt it is a 0% chance that they will get it dismissed. It's nonsense, per usual. Another way to put it into the public sphere and get the cult outraged. Oh my God, the government's blah, 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 motion to dismiss. This will get dismissed. No, it won't. No, it really, really won't. And that's basically how it's going to go with the other motions as well. Bunch of nonsense from the defense. Hank comes in, puts the hammer down, makes them look silly. They leave with their tail between their legs, and they are screwed. What's really going to be interesting is when some of these answers come out. Like when the judge starts denying or not denying these motions, that's going to be what she writes there, and whether she does or doesn't is going to be the interesting part. That's going to be the part. I don't know. Here's the problem. If, and this is a big fat if, because at this point, all indications are showing that she's not actually going to take any of the defense off. But if she did, that would absolutely push back the trial. We would not be starting on the 1st of April if she did that. And I'm not sure, but here's the thing. She can't really use that. You're not supposed to, as a judge, use that as a template for why you're not doing it, is because you want the trial to get on. Because then she'd have to hire other attorneys, and they would have to be filled in on the case, which would take a while. They would have the right to sort of get up to speed without being pushed into it. But I think that's also another reason why she won't, because she wants this over with. Like, she wants it done. We all want it done, Canoni, but we also want it done correctly. We want it done correctly. We want the correct things to happen that are supposed to. If you lie to the court, you should have the correct sanctions for that. Not just a smack on the hand, because a smack on the hand would have been 17 times ago that they did it. It would have been the first time they said, the Fed said they can't let this go to trial in good conscience. That was not only a misrepresentation, but a bold-faced lie. to the point where the federal government had to come out that day, the U.S. Attorney's Office, and make a friggin' statement to the media saying that is not what was said at all. That would have been a slap on the hand the first time it happened. Never mind all the other lies and misrepresentations that have been made in pleadings and to the court. This is the 100th time. Like, so, you know, come on now. That's a hard one. This is a good question, though, Ashley. It's a good question. And if you guys have any questions, because I am going to wrap it up soon, start them now so I can go through them. But one of two things are going to happen here. She's either going to throw ARCA out completely and say they're biased, and I think there's a good bit of evidence to show that they are biased and that they should not be allowed to testify, or she allows them to testify, but the defense is not going to be allowed to say that they're independent or that they were not paid or any of that. That is out, completely out. You're never going to be able to say they're neutral ever again, okay? Because they're not. That's very clear. Unless he effed up. He effed up when he sat there and said, well, Your Honor, I'm not going to say that ARCA isn't biased. He effed up there because you just admitted to the judge that even you think that they might be a little biased towards the defense. And if that is the case, then the judge should not be allowing them to testify. That's a problem. So there's, 1 to 2 different things that could happen with ARCA, but my opinion and my guess is one of those 2 things will happen. And that's another thing. Yes, we have a different U.S. Attorney's Office, and this is why Alan Jackson and his team were basically forced to give these emails to Hank, was because the day before he did, on the 12th, the U.S. Attorney's Office handed over more materials to the defense and to the Commonwealth that were more voluminous than what they had been given before, because there's a new U.S. Attorney in there, because Levy is gone, which indicated to them that they weren't going to keep playing Levy's game, and that Leah Foley was going to actually give what needed to be given instead of trying to hide things. So whether it was given, I think Jackson and his team knew either he was going to give it over and try to save a little face, or the federal government could get it from ARCA and give it to them that way. So in my opinion, he had no choice but to give it over. So because people like to point out, well, he's the one who gave it to them, because he had no choice. It's either that, or if they hand it over, then you really look like a liar. At least you have a small argument if you hand it over. Well, Your Honor, I handed it over. Like, he did not have a choice, which is why he opted to hand it over. But he didn't hand it all over. As we know, there is more. There is no doubt in my mind there are way more communications that we have not seen yet. Exactly. Oh, yeah, he will definitely eviscerate ARCA. There is no freaking doubt that Hank is going to eviscerate ARCA on the stand. Ever. That's happening. Like, I do not think that Cannoni can allow Bettero in. And I expected that we would get something on this soon, and we have to get it soon because trial's happening soon, so it's either a yes or a no soon. But I expect that she can't really let him in. I explained this yesterday, but if you have 2 clients, right? So say me and my husband want to get a divorce and I hire an attorney. He can't then hire that same attorney that I hired, because he can't weigh whether what he's doing for me is more important or whether what he's doing for my soon-to-be ex-husband is more important. Like, that's not the way it works. Your client, their interests, or what you have to do, you can't weigh one more than the other. That's your duty, your legal duty as an attorney. You have to weigh the interests, and you can't decide that you're going to have 2 sort of competing clients, and then so that's why Hank was saying there's a balancing act that I don't know how any attorney could do, because if you get federal documents that Aiden's not entitled to, and they're under a federal protective order that have to do with Karen, how do you then say, well, these I want for this case, and not either give the information to your client or try to get that information for that case when you know you're not entitled to it and has nothing to do with it? Like, that's the problem here. And I just don't think she can let him in for that reason, because you can't ask an attorney to even be in that position. It's not really A, fair, but B, I think that's why they tried to play that game to begin with. I honestly think the only reason Boudreaux, there's two reasons Boudreaux wanted on there. One was for clout and fame. He's a friggin' clown. And the second one was to try to like get stuff that he knew he couldn't get otherwise. Like, a neurosurgeon, I mean, I would guess because he had a head injury. So they would call a neurosurgeon to explain what would happen after someone hit their head that hard. Would they be able to move? Would they be knocked out? Would they have turned over on their side? Would they have like I'm guessing they're going to have the neurosurgeon to sort of explain the raccoon eyes and how the blood pools to the front of the head and how that happened. And what could happen when you hit your head, what it takes to actually hit your head and get knocked out or have swelling of the brain, things like that. I think that's why you would have a neurosurgeon testifying. Those would be the really big reasons why you would have one testify. It is sickening. You are right. Well, that's the problem. Within 24 hours of the protective order being violated in Karen's case, it was violated in Aiden's case too. Gee, I wonder how that happened. Doesn't take a rocket scientist. You know what I'm saying? Like, that's the problem too. The defense is the only one that gave the DOJ anything. They never asked for a single thing from the Commonwealth to prove their quote theory wrong or right. And that stinks of corruption to high heaven. And in my opinion, someone needs to be held responsible for that. I don't give a shit if it's Levy himself, but someone needs to be held responsible for what happened here, and people need to start demanding answers. The only way to demand answers is call your local reps and senators and tell them you want to know why the U.S. Attorney from Massachusetts was allowed to subvert justice in this way as a favor to the defendant in a murder trial, especially when they found not an iota of a goddamn thing. Yeah, exactly. His hand was forced, but we certainly did not get all of the communications with ARCA. The fat chance. There's more. Fact. Well, that's another problem. That's what Canoni wanted to be very clear about this morning, which was you have a duty to know. So you just can't claim ignorance by saying, I didn't know, Your Honor. You have a duty to know. They're practicing under your license. That's not a fucking excuse. And that was her point. Exactly, Brie. I'm sorry. I'm behind in the comments. Yeah, it's a huge conflict. I don't see how she could let him in. I honestly don't. If she let him in, I myself would be screaming from the rooftop that like maybe she's not the judge for this case then, like, because that don't make no damn sense. Like, unless she's got a damn good reason or a damn good way that he like, oh, but this defense attorney's not going to be able to allowed to be looking at these materials unless there is some way to do that, which I don't think there is, not legally. That would be insane. It wouldn't make any sense. You know, of course he has, because he's betting on praying that he gets into this case. And if he's out there talking the entire time, that's something that our Hank's going to bring to Canoni and say, Your Honor, this is what we got going on here. Like, that's why he hasn't, you know. Oh, have a good nap, Ren. Have a good nappy poo. Anybody else got any other questions? Because I'm about to wrap it up myself. Yeah, exactly. And they still found nothing. The federal investigation still found not a goddamn thing. I agree he should be taken out of the media box. I'd like to know why he wasn't there today. Is he not there today because he had something he had to do? Or was he not there today because he's been told he can't be in there and he's just not making that public because that would be freaking embarrassing? I wonder. Oh, lunch. That sounds so good. Submit another affidavit regarding Better according to the doc. Yeah, I haven't seen it on the docket, that's for sure. Believe me, I keep an eye on that on the docket. Well, here's the thing. I love you all. I love your faces. We've been here for 5 hours and I'm hungry myself, but don't forget we have an outro and some people love to watch the outro. So I'm very proud of my outro and my intro. But please do like, please do share. Protective orders? I'm not sure. Is that what you mean by POs, protective orders? Like, share share with your friends, share online, share in text message, but make sure you hit the like button. Make sure you put your notifications on, put the bell all the way to all. Otherwise, you won't know sometimes when I'm on. It'll only do it sometimes. And if you want to donate to the channel, because that's how we run over here, because we're small, you can do so with this information here: Cash App, Venmo, and PayPal. I appreciate you and I love you guys. If you are on my replay crew, I will read your donation if you choose to donate. After I'm not live anymore, I get to read it on the next show, and you get to look for it there. So I love you guys. I love my replay crew. I love you guys. I appreciate everybody being here with me, and I will see you guys tomorrow for another explosive hearing to find out what in the hell is going to happen with all this stuff. And I will keep an eye on the docket, so keep an eye on my Twitter. If I see anything, I'll tweet about it, obviously, and we will address it. All right, everybody, have a good